just went to Zoom.
That's what
Okay.
You're gonna be my keeper.
I'll be your keeper.
You'll be my keeper of the online people. Works better.
So far it's working.
Huh?
So far it's working.
Yeah, it worked great last time. Kept me on the straight and narrow.
All right, I think I can do this paper-based today.
Can I get some water before we get going? Aaron, can you use that? Can you, all right?
You got two of those? Yes. Yes, please.
Here you go, my friend.
Thank you.
Okay, well, I'll give him a couple of minutes. We'll give him a couple of minutes here. Give him about 5 after, and then we'll start. Is there a short chair? That's appropriate that there's a short chair.
Locked in, can't go that way because the door handle is broken.
We'll be starting in a minute. We're just waiting for another commissioner. So if he doesn't show up here in a couple minutes, we're going to get started. So.
On the Airbus?
Yeah.
I can't believe United hasn't done the same thing with that Denver flight. Well, you've done that one.
Yeah, they did. Really?
It's full, but they're still flying that CRJ 200.
Yeah.
I did notice they're going to update to the bigger, the 700, which at least it has first class and it has a bathroom you can stand up in.
Nice. Yeah, I'm super excited about that.
No, little things.
Nice.
Right. Because boy, that's a busy.
So Brandon, no word from Chris?
Nope.
Okay, well, we're going to get started then. Is this on?
Yeah.
Is it important to?
Speaking, yeah,
Oh, yeah,
speaking
you
to the
have
mic.
to. Yeah.
Yeah.
We want to hear what you have to say. You're doing good so far.
Okay, everyone, I'm going to call the special meeting of the Planning Commission together. Can we have roll call, please?
Commissioner Allen,
Here.
Commissioner Bolton, Commissioner Delves, Commissioner Locke. Here. Chair LePage.
Here. Okay, I want to welcome you here all tonight. This is a workshop, as you all know, for the draft wireless ordinance. We do have a couple of things we need to get through on our agenda. First, we have, are there any public appearances? Is there anybody here from the public that wants to speak to the Planning Commission on any matters which are not on our agenda tonight? Anybody online there, Stephanie? Got their hand up?
No? Oh, wait. No. No.
Nobody? Okay, I don't see anybody raising their hand, stepping forward, so we'll move on to the public hearing tonight. which is the workshop for the wireless ordinance draft. This is a workshop. It's an information gathering meeting, which is a little different from our regular meetings. There's no resolution. We're not going to make any decision. The whole intent tonight is just to gather information, direct it to staff for any changes or additions that need to be made to the draft ordinance. And tonight, we're going to try to kind of focus the discussion. We're going to have, first of all, Brandon, the director, would like to make a few comments, and then we'll do the staff presentation, and then we'll move on to commissioners' questions to staff, and then we will move on to the public comment. So at this time, I'm going to turn it over to Brandon. He's got a few comments he'd like to make.
Thank you, Mr. Chair. I just want to note, I'm getting a couple messages that the video is not coming through on the Zoom yet. Sebastian, can you confirm that we've got that going?
It's not coming through.
You got it?
It's not coming in.
He's working on it at the moment. So he's working on it at the moment. I think just people won't be able to see us visually at the dais. I know Sebastian's working on it. He'll get it fixed. But I think we can continue. It's just seeing us visually on the screen. They won't be able to do. I'm going to share a screen with the Zoom folks for our presentation. So if you guys are okay with that, I think we could.
They can hear us?
They can hear us fine. Yeah.
Okay.
Yeah,
Just the video
they
isn't
just
working?
can't see us right now. So
Video-
we're working on the camera. Yep, and we will share that via the Zoom platform, so it'll just show on their screen. So it's just a video, like that video camera up there for some reason is not working right now. So it's just that. But we are working on it. So thank you, Mr. Chair. I want to thank, I'm going to start with thank yous because I think those are important. I want to thank, first and foremost, all of the folks that have been involved in collaborating with the city over the last many months on this draft ordinance. So thank you to everyone that's here in the chambers, on the Zoom, that isn't here tonight but has sent in comments, and those that are just commenting via Spirit. I appreciate that too. Thank you to the planning commissioners for your extra time in reading all the materials, and thank you to our outside counsel, Gail Karish, who's been a big help as well with this. So we're going to go through a presentation, a staff presentation. We're going to talk a little bit about the goals of the workshop, some background, how we got here, some of the questions that, if you remember from earlier meetings, that we're trying to answer with the ordinance, overview of the structure, and some of the next steps. So I do, as the chair said, this is information gathering only tonight. We're not, nothing's finalized. Nothing that went out was a final draft. We're really trying to get as much feedback as we can tonight. So I'm putting up on the screen right now, hopefully folks on the Zoom, and if someone can confirm for me that you can see the presentation. I see a head going up and down. We did it. Okay, fantastic. Okay, so we've got a PowerPoint up on the screen. I'm going to move it over here so that people in the room can see it too. There we go. Fantastic. Okay.
Brandon?
Yeah.
Can you do full screen on that for the?
You should be able to
We see it, we got a full screen.
No, but we're seeing both. We're seeing your next slide and.
Yeah, on the Zoom, it's,
Oh, okay.
It's
Let me
not
see
a
if I
full
can
screen
minimize
yet.
that. We might just have to be okay with
There,
that.
that's better.
Yep. Okay. The joys of technology, right? Okay. So we've got, as I mentioned, this is information gathering only tonight. We're not really here to. Man, we are just having all kinds of fun tonight, aren't we? Not here disputing what can and can't be in an ordinance. We want to hear what people think might need to be strengthened, what could be worded differently, if there's large gaps, things that you like. I mean, if that comes out tonight too, if someone says they like something in the ordinance, we're not opposed to hearing positive things as well. So this is really, please give us as many specifics tonight as you can. This is information gathering because what's going to happen after this is a redraft. So please be as specific as you can tonight. So as I mentioned, we're collecting feedback on the specific areas of concern in the ordinance package. So after the workshop, we're going to redraft. So it'll be staff working again with our outside counsel, Gail Karish. We're going to return to the PC in a few months with a redrafted ordinance. That presentation will be a lot more specific. When we come back, we will take note tonight. So think about tonight as making a checklist. Basically, we're going to make a checklist from the Planning Commission, from the public on things that people think should be maybe done differently or strengthened, or again, if you think something's great, please let us know. We'll make that checklist, and then when we come back with the redrafted ordinance, it'll either be we took a suggestion as it was given and inserted it exactly how it was suggested, or we modified the suggestion in some way, shape, or form, and here's why, the legal reasons or the functional reasons or whatever. And we'll bring that back to the next Planning Commission meeting. And that next Planning Commission meeting is a little more formal. This is, again, as the chair mentioned, a workshop. So the next Planning Commission meeting will be hoping to get a recommendation to the City Council for the 2 readings for adoption. So that is, that's sort of the structure and the next steps for this. So I'm going to give a little background here. As I mentioned, there have been some public meetings already. If you recall, the City Council asked the Planning Commission to give feedback on some key sort of land use areas back when we had our joint meeting, and then that Planning Commission workshop back in June of 22. And then in August of 22, we did release some initial drafts. They were formatted in 3 separate ordinances, draft wireless applications. We received a large amount of public feedback, really good quality feedback. And so we had a workshop planned back there in late 2022 that we actually postponed because we realized, hey, we missed the mark. The city's not above saying, hey, we didn't get it right the first time. So we went inside ourselves and looked at the ordinance package again, met with some of the interest groups locally, met with third-party counsel, gathered more feedback, and that's what tonight's redraft really represents, is what we did after that first launch that maybe didn't hit the mark as well as we had hoped it had. So the ordinance you're looking at tonight is one consolidated ordinance. It still has separate application forms and guidance documents, which we'll talk about, but it did incorporate a lot of that community feedback. So just at a high level, I want to explain what you're looking at in this package, how it's structured. So you have the ordinance, which lives in the municipal code, the zoning code. This is the law. This is the zoning code section 17.46. It focuses on the procedures and does include general development standards, including design, things like height, stuff like that, for all types of wireless facilities. The thing to keep in mind about an ordinance is that because it's in the zoning code, if you want to make any changes to that, it takes 8 to 12 months because not only is it Planning Commission, 2 meetings at the City Council, but then you also have to get on the Coastal Commission's agenda because it's part of our local coastal program, which does take some time. So think about sort of bolted on to the outside of the ordinance are these administrative documents, which include the design standards, more detailed design standards, because as I mentioned, the ordinance does have design standards in it. Specific conditions of approval, the application forms, and an application material required checklist. So these are all really important documents that are specifically named in the ordinance so that they're incorporated by reference, but they live outside of the zoning code so that if at any time, let's say a regulation changed to the federal or state level, we wanted to shore up a hole in the materials that we're requesting from applicants, we can do that much faster because the ordinance gives that authority to the Planning Commission to modify those documents versus having to go through and update the entire zoning code once again. So it's an important distinction there just to understand how it's structured. So one of the things we're going to do here between Gail and myself just kind of quickly is go through some of those high-level policy questions that we heard from the first couple of public meetings, both the joint meeting and the June Planning Commission meeting, that the ordinance was essentially called upon to answer or explore. So we're going to run through these relatively quickly, but we've got them broken up into A, B, and C, AB 1, 2, 3, 4, et cetera. So with that, I am going to introduce Gail Karish to run through the A's here. As I mentioned, Gail is the city's wireless attorney that we've been working with, and I think has been doing a great job. It's been a great partner in this. So Gail, welcome. Thanks for joining us, and please go ahead.
Thank you, Brandon, and I'm glad to hear that it's just the camera not working and you don't have a power failure or something like that.
No,
so,
just the camera.
Yeah, that's great. So yeah, I'm going to tackle just briefly the items that were when we posed a number of questions way back when we had that joint session. There were items that the council said, obviously would be included as part of the package, but that they felt that they had particular expertise on, were making those sorts of decisions, and they were relying more on the planning commission for their input on the things that planning commissions are known for, dealing with design and location and those, like the heart of the sort of zoning regulation. So very quickly, this is the list of the things that the city council said were mainly in their purview, but we're just going to go through here, and obviously anyone can comment on them as we go through. These are how we resolved them for now in the draft ordinance. So the first question was, should you have ordinances or policies? And an ordinance, as Brandon mentioned, takes quite a procedure to revise. Policies are a little bit more nimble, so a little easier to respond to changes in the law or changes in community preferences and things like that. So first question was whether the city council should develop rules and procedures tailored to each regulatory category of facility, and that's really talking about the FCC shot clocks that they've come up with for different types of facilities. So whether they should develop rules and procedures tailored to each regulatory classification and adopt them in codified ordinances versus policies adopted by resolution. The approach we took in the draft ordinance is that all the procedures and the general location and design standards for all types of wireless facilities are in the ordinance based on the FCC regulatory categories. What we left to be in more of a policy or guideline format are the things that Brandon mentioned already, resolutions that would be adopted by the Planning Commission to deal with detailed design guidelines, application requirements, and standard conditions of approval. The question number 2 was with respect to application forms and whether to delegate the authority to the planning director to develop detailed applications. The approach we took in the ordinance is to have that authority delegated to the planning commission and not to the director. So it would be adopt or modify any application requirements by resolution of the planning commission. Question number 3, initial decision maker for certain types of facilities. So the question was whether the initial decision for eligible facilities requests, small wireless facilities, and AB 2421, that's macro cell site generators, should that be an administrative decision plus an available appeal? And the reason those 3 were sort of called out because they have the shortest shot clock. So it's trying to balance the kind of timeline that federal law and state law with the granted remedies gives for review with the procedure that you would use to go through that review. So the draft ordinance actually delegates authority to the director only for one of those categories, and that's for eligible facilities requests. Eligible facilities requests are ministerial. The Federal Communications Commission sets the rules for what qualifies or does not qualify and sets a 60-day shot clock and a deemed granted remedy. So that where there's no discretion was in the ordinance, we placed that initial decision with the director with an appeal to the city council. And this is the only one. All of the others are discretionary decisions. So we put them all with an initial decision at the planning commission. But these are short timelines, so that that will require some flexibility on the part of the planning commission to be able to schedule meetings to meet these shot clocks. There's a 60-day and a 90-day shot clock for small wireless facilities. And then there were obviously also an appeal. The draft ordinance on the last category, which was macro cell site generators, or adding a generator to a large standalone cell site. We don't address this at all in the ordinance, and that's because that law actually will sunset at the end of this year. And you don't currently have any macro cell sites. So, by the time this ordinance would go into effect, that law will no longer be on the books. So we don't address it at all. The fourth one, appeals. And the simple question was whether appeals should go directly to the city council. And that is indeed what we have proposed in the draft ordinance. All appeals go, from whoever makes it, goes directly to the city council if there is an appeal of any of those decisions. And I'll turn it back to Brandon.
Thanks, Gail. So I'm going to go through the B's and the C's really quickly. So this section B talks about location, preferred versus discouraged location. So we're going to run through these 4 questions. First question was whether cities should prioritize installations on existing structures over new structures that might be in a more advantageous location. So the draft ordinance currently and the guidelines do prioritize existing structures, so we're not creating new structures in the city. And I think at this point, I just want to remind both the Planning Commission and the public that we're going through this. This is what the current draft in front of you does. All of these things are open for discussion and direction to change. I'm going to sound like a broken record. None of this is a final draft. We're here for a workshop tonight. So if there's something that the ordinance is trying to do here that the Planning Commission feels is maybe needs to be done slightly differently, please share that with us, because that's the feedback we're looking for tonight. So question B2, should the city prioritize co-location of multiple facilities on the same structure? Draft ordinance and guidelines do favor co-location. Again, fewer facilities spread across the town. Ranked preferences, which zones, locations, and support structures are the most or least appropriate for wireless facilities, and how should the city rank those zones, locations, and support structures? So the draft ordinance does attempt to do this. It makes locations such as residential, right-of-way, historic resources, and coastal areas the least compatible locations. You probably noticed from the first draft of the ordinance that we even changed the language. Rather than saying most appropriate, we start with least compatible. So we're making it clear that where the least compatible areas are. So those are ranked in order, and you'd find those in the actual ordinance. The draft ordinance also does make new support structures the least compatible. Question B4, whether approval for wireless facilities in any specific zone or locations should require a special exception. And the special exception term is important in your brains to sort of pair up with the term that gets used of effective prohibition. So an effective prohibition is always a special exception, but there are more special exceptions other than an effective prohibition, but effective prohibition is the most common one. So the draft ordinance does require a special exception finding or proving this effective prohibition for right-of-way locations within the single-family residential or anything else that's those least desirable locations. If you're going to put it in our least desirable location, if you're going to propose to put it in our least desirable location, you're going to have to prove that effective prohibition. So that's where that line is. So then I'm going to go through the C questions really quick. You can see them up on the screen. These are not about location as much as they are about design. So stealth standards, should all new wireless facilities always be held to a concealment standard of complete stealth? That seemed like a no-brainer. The draft ordinance and guidelines require stealth and concealment for all locations. Number 2, whether and under what circumstances the city would prefer taller and narrower facilities over shorter and wider facilities. The draft ordinance does prefer taller, but does limit the height. Limits to 24 feet in the residential district or 30 feet in the commercial district, which are the development heights allowed for other development in those districts, or 10 feet over the average tree height, whichever is the most restrictive. And I'll let that one hang for a second, because that's really important. The way we wrote this ordinance is that applies to everything. That applies to right-of-way, private property, anything, telephone poles, whatever. In the residential districts, a wireless facility cannot be taller than 24 feet or 10 feet over the average tree height, whichever is most restrictive. So it'll never be taller than 24 feet in the way the ordinance is written in the residential district, if for some reason they were able to prove that one could go there. Question 3, whether and under what circumstances the city would prefer equipment mounted on support structure or poles versus mounted on the ground. The guidelines contemplate the preferred structures being preferred over ground-mounted equipment. Most prefers undergrounding if it won't impact healthy trees, but also recognizes that there is some infeasibility there. And then number 4, whether and what circumstances battery backup would be required. The draft ordinance does note that it could be part of the accessory equipment, but does not state any preference or requirement for that. Because there's those volume limitations. So again, that's something we're looking for feedback on there. So what I'd like to do now, so those are all the questions. Those are the bigger questions that we garnered from those first couple of meetings that we tried to answer with the ordinance. Just want to give a quick procedure overview about the application types. We talked about these a little bit already, but one of the things in this redraft going from the 3 ordinances to the 1 is that if you recall, there was a draft ordinance that was put out by a local group prepared by Mr. Campanelli, an outside third-party attorney, that used some different structures. One of the structures we pulled into the city's draft ordinance was this naming convention, the type 1, 2, 3, 4, 5. We thought that was really good, and that got a lot of positive feedback, so we pulled that in. So you can see on the screen all these different types, and they're lightly defined on here, but they focus on the shot clock times, which are in red. So type 1 is a new small wireless facility, and type 1 and type 2 fall under an existing structure, which is worth clarifying that an existing structure doesn't necessarily have to have a wireless facility already on it. An existing structure is City Hall. City Hall doesn't have a wireless facility on it. It would be considered an existing structure under this ordinance. So type 1 is a new small wireless facility with a 60-day shot clock. Type 2 is a new facility that doesn't fall under those defined terms of small wireless facility and has a little bit longer shot clock. These are on an existing structure. For a new or replacement structure, those are considered type 3 for new small wireless facilities or replacement structure, and those have a 90-day shot clock. And then pretty much any other personal wireless facility that doesn't fall under one of those first 3 that we talked about or the one that I'm about to talk about is considered a type 4. It's a catch-all category and it has the longest shot clock of all of them. And just to reinforce what Gail said earlier, all of the ones that I just talked about, type 1 through 4, go to the Planning Commission. So none of these are administratively reviewed. They're publicly noticed. There's a public hearing. They're appealable to the City Council. So that takes us to the type 5, which are eligible facilities request. And that term is very tightly defined by the FCC, and you have to meet very specific criteria. So think like on top of the Dowd Arcade. There has been and is an existing Verizon canister up there. It looks like a chimney. That's an eligible facilities request because it's already existing, it's already there, and someone can apply to increase it by a certain small percentage. If it goes over any of that or it defeats the concealment, then it no longer counts as an eligible facility request and will get kicked into one of the other type 1 through 4. But if it's truly an eligible facilities request and it meets those criteria of not defeating the concealment and not getting bigger than it's supposed to, then that is the one type that would get reviewed administratively. Still going to get public notice, just like we do for all other administrative decisions. Just wouldn't have a public hearing. The difference is, though, is that we thought it was important to have an appeal to the City Council baked into that. So depending on the outcome of that review, it could be appealed to the City Council. So that's just a quick overview on the application types and sort of how they get processed. This is the decision-making process. As I mentioned, discretionary review types 1 through 4. They require use permit, public notice, public hearing, and they go to the Planning Commission. I mentioned the type 5, the EFRs, go to the director for an administrative review. The ordinance has very specific findings that must be made in the ordinance itself, and it references other findings that exist elsewhere in our zoning code. So by reference, it references other findings that must be made in the zoning code, and you can find that in section 17.46 of the ordinance. And as we mentioned earlier, all decisions regarding a wireless facility are appealable to the City Council. So I talked about development standards existing both in the ordinance and then also in those bolted on documents that are incorporated by reference. So there's just a quick rundown of some examples of the development standards that you would find in the ordinance itself. I'm not going to run through all of them because I know this is running a little bit long, but things like the ranking for the location, the preference for structures, those highly incompatible areas like all of the R1, near a historic structure in the coastal zone. Those are the ones that require those special exception findings, or remember the effective prohibition findings, those are in there. And then general design standards, these again, you're gonna find in the ordinance, not in the bolted on ones. Things about stealth and concealment, height limits, I talked a little bit about earlier. Fire safety, we got some great comments early on when we started drafting about beefing up the fire safety sections of the ordinance, which was a great comment. So we have that in the ordinance as well as in the bolted on documents too. And you can see what else on there: finishes, noise, lights, landscaping, etc. And then this is just to give you an idea of what lives in those sort of bolted on documents that aren't in the ordinance themselves. This is from the bolted on design guidelines. It's more detail. It's additional design requirements of the ordinance. And remember, the ordinance says you have to meet all of the requirements within the ordinance, within the zoning code, and you have to meet the requirements in these detailed design guidelines that live outside of the ordinance as well. So they're incorporated by reference. They're required to be followed. And then so after tonight, so what happens after this? So we're going to, as I mentioned, we're going to take feedback. This is a feedback gathering meeting, feedback and direction from the Planning Commission and the public, and then staff and our attorney will work to draft a final version to bring back for Planning Commission consideration. That hearing will then consider that revised draft and make a recommendation to the City Council. That's going to also include adoption of those bolted on materials that I talk about. Those are the ones the Planning Commission adopts by resolution. Then we'll have 2 City Council hearings, first reading and a second reading, or more perhaps, but a minimum we're going to have 2 City Council meetings. And then because the ordinance lives in our zoning code, which is part of our local coastal program, we will have to move it along to the Coastal Commission for certification of an amendment to our LCP, the local coastal program. And after that, it would be official. So we still have a long ways to go, a lot of process, but there's definitely more to come. So as I mentioned, we're seeking feedback tonight from the public and the Planning Commission. The more specific everyone can be, the better. We're going to try something tonight. I spoke to the chair, and this is a public workshop, so people can say what they want to say, but we're going to try our best to compartmentalize, at least at the beginning, so that it'll help the Planning Commission and staff take notes on what people think might need to be modified within the ordinance package. So when we open it up for general public conversation, we're going to try to go, like, does anyone have comments about the application material requirements, that part of the ordinance? If you can give us your thoughts on that, then we'll come back to the next topic, which is location and design standards. We'll try to go one by one and see if we can compartmentalize it. If it doesn't work, it doesn't work. We're going to get everyone's comments by the time we all leave here tonight. No worries about that. And of course, we have the last one is all other comments. So we're going to try to focus some of the bigger topics that we think people are most interested in talking about, so we can all take concise notes about what areas of the ordinance might need to be adjusted. And then, like I said, we'll go and redraft and bring it back for another round of this. So with that, thank you for your patience. That was a long presentation. I would suggest if the Planning Commission has questions of staff, maybe ask those questions. And then I know we have Mr. Campanelli would be, I think, is queued up as your first public comment on behalf of the group that he's representing. But staff is happy to answer any questions about the presentation that we just gave you.
Okay, are there questions for staff at this time?
I have a question.
Commissioner Locke?
Thank you. Can you describe for us more specifically the shot clock shot clock process? And my experience has been that essentially when somebody submits an application, that starts the clock, and that at that time staff has an obligation to determine whether or not the application is complete within that period of time. And if the application is incomplete, to notify the applicant of whatever deficiencies are there. And then the applicant has an opportunity to submit the additional information to complete the application. And how does the clock stop, start, and ultimately what is, and I know we ran into the situation with this last application a couple of years ago, where does that risk come into play if certain things are not done within a specific period of time?
Well, that's a great question, and I'm gonna start at a high level, and then I'll let Gail answer it because she's far more of an expert on this than I am. But I'll start with sometimes the shot clock conversation gets confused with the Permit Streamlining Act. So the Permit Streamlining Act governs your typical development. Think you're building a new house or anything like that. That's a law that governs when an application comes across the counter and the fees are paid for the application. At that point, it starts a clock. And then the process you're describing, Commissioner Locke, is, when we send back something to an applicant that says, you're missing your drawings for this, and then that stops that clock, and there's this back and forth. The shot clock process is a little bit more nuanced and favors the wireless industry a little more than the Permit Streamlining Act. So it's not necessarily always predicated on when they come in and pay their fees. It's more about when you require something in the process. So for a good example of this would be community meetings ahead of time. So if a city requires a wireless company to host a community meeting before they submit their application, the fact that the city is requiring them to do something starts that shot clock. So that's one sort of nuance. Like I said, it favors the wireless companies a lot more than the Permit Streamlining Act does. So that's one little nuance. The other nuance is that, and I'll let Gail speak to these, is that there are fewer things I believe that stop the shot clock than with the Permit Streamlining Act. I also do know that between the different application types, we talked about the eligible facilities request. That's the ministerial thing that Gail was talking about. That's the the automatic approval basically. So you talked about risk. That's why that one happens at the director level, because it has to move a little bit quicker, because if you get to the end of that shot clock, it's just approved. There's no other remedy. So Gail, how'd I do? What else is there to talk about with shot clocks?
Yeah, you did great. Let me just add a few more details. So one thing just to note on the last point you made on the risk, at the federal level, in the FCC rules for eligible facilities requests, that's where they have the deemed granted remedy if you miss the shot clock deadline, so you don't act within the shot clock deadline. Actually, state law in California has a deemed granted remedy for all the other shot clocks. So every one of the shot clocks we're looking at on this page has a deemed granted remedy that an applicant may invoke if you do not complete the process within the allotted time. The rules, there are the general rules for all of those shot clocks is you can always agree with the applicant to stop the clock or extend it. My experience has been that applicants are often willing to agree, but you can't rely on it, right? So sometimes that's how the clock gets stopped or gets lengthened, is because of an agreement with the applicant. Aside from that, what we're dealing with is for the small wireless facilities, the staff actually have to turn around an incompleteness notice if they review the application and find items to be incomplete within 10 days of receiving the application. And the first incompleteness notice for a small wireless facility, so that would be type 1 or type 2, actually just ends the shot clock. And when the applicant resubmits, that's when it starts again. So you don't lose any time by taking the 10 days to review. After that, once they resubmit, then they're under the same rule as all the other shot clocks. The staff have 10 days to review and find if there are any still remaining incompleteness items, and get their notice out to stop the clock again. It doesn't start again until the applicant resubmits. That's for type 1 and type 3. Those are small wireless facilities. For type 2 and type 4, and for type 5, when the application comes in, you have 30 days. The staff have 30 days to review it and send out their notice of incompleteness. But that time that they take to review eats up the shot clock. So it's always in the staff's best interest to get their notices out as quickly as possible if there's incompleteness, to stop them. They start and stop based on when the applicant resubmits, and you have 10 days to send another notice. And then they include appeals. So that's where it can be quite challenging to complete the entire process if the applicant isn't willing to agree to more time. So that's why sometimes when we're doing these updates, we're looking at shortening up the time period for getting your notice of appeal in, or we're also looking at we have an administrative decision that then would go directly to the city council, because we don't really have time for 2 levels of appeal where you might normally go to the planning commission first.
And one thing, if I can add, this was something that Gail put in the ordinance that I thought was really savvy, is that typically when we do noticing, so we do our typical noticing for both administrative and planning commission meetings, we put the responsibility on applicants, because it's in their best interest to get to their hearing on time. So like when someone's responsible for going out and handing out within 100 feet in person, we typically put that on the applicant. With the wireless ordinance, the way we wrote it is we're retaining that responsibility in City Hall because of what Gail just explained. Unscrupulous, nefarious wireless company could take 3 weeks because we'd have to keep continuing the meeting. They could take 3 weeks to give out their notice, and that would continue to eat away at that shot clock. So I wanted to give Gail some kudos for thinking about that. That's a way to kind of plug one of those risky holes with the shot clock. So that is in the ordinance, actually.
I have another question. So knowing these dates or shot clock time frames, do we have staff and resources on our team here to be able to adhere to these? And do you feel confident that we could stay within those days?
I do. That's a great question. I thought about that as we were going through and writing these things, like staff taking on the noticing. I kind of zoomed up a minute and thought, okay, how many wireless applications have we actually received in the last X years? Not that many. If after this ordinance goes out for some reason we get 10 a week, my answer is going to change. I don't foresee that happening. I do think it's still a pretty slow trickle. So I feel comfortable. We're writing this ordinance in a way that makes it a priority, so we will treat it as such. Yeah, that's a good question, though. I definitely was part of the consideration.
Okay, are there any more questions for staff? You look like you had one.
And this kind of goes to the application, and my question's more, when you have somebody who makes an application for this type of structure, or this type of facility, how does the city know that that person is truly representing that particular company? I mean, I know, contractors represent builders,
Mm-hmm.
represent, architects are involved in a normal building situation. But in this type of corporate situation, how do you know that the person who's coming to you is actually authorized to speak for the company, and do we have certain
It's a great question.
things
So
that we put in place?
in the application, so one of the documents we've created as part of this ordinance package is the actual application. So if you look at the application, there's boxes on there for a property owner. So if there's a piece of property, private or public, that person needs to be a signatory on the application, just like with a development project. The company representative, someone who's authorized to speak for the company, needs to be a signatory on that application. And if there's an agent or an applicant, they need to be on there as well. So we have all that we need to get up front, like we're not even gonna talk to you unless that's on the application.
But is there some way to verify? I mean, I'm just thinking bigger picture on certain big applications. Is it verified?
I mean, Gail, do you know, I'm going to take that note because that's a good question. I don't know if there's a way to verify like company approval for someone to be the one submitting an application on behalf of like Verizon or one of those folks.
Yeah, it doesn't it hasn't typically come up that, so I can't say for certain if other cities have found a way to really deal with that.
But we can look into it.
I think request they certify that everything they say is true, but we usually it's quite obvious that they are representing someone, because say the plans that they submit usually have the name of the carrier, the underlying facility owner, Crown Castle or Verizon or whoever. So usually we're pretty confident that they are the representatives, but we can certainly look at that.
Yeah, and that's a great example. I mean, I didn't pay you to do this, but that's a great example of a question or a comment that we don't really have an answer for, but we'll come back in this next round. We come back with a redraft of either putting something in there or not putting something in there and telling you why we didn't. So thank you for that.
Mr. Delfs.
Brandon, let's just get this one on the table now. That in reading the vast amounts of stuff that's come in from the public, a common theme that is getting voiced is that this ordinance does not include a requirement for the applicant to provide probative evidence of need, as number one, and also does not require that evidence to be submitted as part of the application up front. And then the third piece of that is, in addition to probative evidence, that other sites that have already been approved but not turned on need to be turned on before they provide probative evidence for future sites. So the question is, I guess to you and Gail, is why are those things that were in the Campanelli version of the ordinance, and yes, he's a third-party attorney, but they was in that one, why are those not in this one? And I'm trying to get it on the table because I think it's going to come out anyway.
Yeah, sure.
We should tease it out, and especially before we hear from Mr. Campanelli.
Well, and thank you for that question. And I just want to, we'll give you the best answer we can, but just recall we're trying to, gather. If that's something that we tease out of tonight is like one of the most important things, then we'll do some more work, because obviously some people feel that we didn't go far enough. I mean, you can look at the application requirements. There's a lot of requirements within the application. We talk about, when you trigger that special exception, that is effective prohibition that requires more information. So our application documents, in conjunction with the ordinance itself, we feel do ask for that information. But if between the public comment and what the Planning Commission gives us direction on tonight feels that falls short, then we will go a little farther and do some more research and explain. So Gail, maybe you can talk just briefly to it, but I don't want to go too far down the rabbit hole of saying why Mr. Campanelli is right or wrong and why we're right or wrong. I think that's not necessarily the spirit of tonight. It's more about finding out where we think there's some deficiencies, and we can come back and answer that. That's fine. Yeah, okay.
Yeah, well, I think, let me just comment on the last issue first, and that was whether you could require other sites that have been approved to be turned on or before you would apply for another. I think that's how I heard it phrased. There is an FCC order that does not allow a moratorium on applications. So that would be the kind of thing that an applicant would claim violates that prohibition on having a moratorium on applications. What I would expect them to reply on that. On the prohibition and application requirements. So what we've done in the ordinance is we don't refer to any. So we refer to an effective prohibition and the federal law, but not the judge-made interpretations or FCC interpretations of that law, because in the ordinance, then that is something that can stand the test of time, even as what would be the appropriate evidence or test to prove an effective prohibition may change over time and has changed over time. So that's in the ordinance. Where what kind of evidence you might have to submit, that's really a discussion about what should go in the application form. We did put requirements in the application form to provide. We put the burdens on the applicant, and they are to prove up their case, which may require different evidence depending on why they're claiming there's an effective prohibition. So we didn't choose a particular set of documents that would have to be included, but we did make suggestions on what we think should be included.
All right, does that help a little bit?
It's probably going to take some time, but yes.
Okay,
thank
okay.
you.
Okay, are there any other questions from the commission for staff?
So I want to let everybody know we're doing our best here. So I think the cameras are dead, but I just put a laptop on the dais here that's pointed. I'm trying to get as many commissioners in it as I can. So if you're on Zoom, there is a new video there called Council Chambers, all in capital letters. I will do my best to spin it around when people come up and talk at the dais. It's going to be a Zoom close-up view, but we're going to do the best we can. We're going to MacGyver this meeting into submission here. So there is a video now on there if you want to see what's going on in the chambers.
Okay, so we will move on to the public comments. I know that the stop cell towers in our Carmel neighborhoods, excuse me if I don't get these names, these organizations quite right, but they are, Mr. Campanelli is online and he would like to make a presentation. With regards to time tonight, I'm going to allow Mr. Campanelli the time that he needs to make his presentation. I also know that the group has
It's like a YouTube video.
YouTube video presentation. I'm going to allow them to make that. And I'm going to ask that the other comments from the public be limited to 3 minutes, although we have multiple topics. So if you want to come up multiple times, that's fine, and make comments. So it's going to be kind of loose. But the whole intent tonight is to gather as much information as possible to allow everybody to have an opportunity to speak on whatever topic they want to speak on. And so that's the intent. And if you need extra time or you feel you haven't been able to get your point across, or you want to talk about another point that's come up, just raise your hand and I'll acknowledge you and have you come up to the dais, and you can have that time to speak. So.
And I'm sorry, Mr. Chair, can I have one more thing before I turn it over to
Go
Mr.
ahead.
Campanelli? So I just want to be clear. So I wanted to, again, thank Mr. Campanelli for the time he spent with myself and Gail Carriage as we were drafting this ordinance. You know, he was a great resource to have. We also partnered with the Stop Cell Phone Towers in Carmel Neighborhoods group here locally. I want to remind the commission that Mr. Campanelli doesn't work for the city. He's not under contract with the city. He's not a legal counsel for the city. He's admitted to practice law, I think in New York and New Jersey. You can correct me if I'm wrong, but I don't believe in the state of California. So he represents the local group. So if you have questions specific about, you know, the law, our city's wireless attorney is Gail Carish. But we're glad to have Mr. Campanelli here. I'm excited to hear what he has to say. He's got a lot of great points that we, like I said, we learned and incorporated into our ordinances we went through. But I just want to sort of guide the Planning Commission that, you know, you're getting a presentation from Mr. Campanelli. It's not meant to be necessarily a back and forth asking his legal opinions.
Brandon, can you stop sharing?
Sure.
Okay, so is Mr. Campanelli, is he ready to make his presentation?
I am. And if you just give me a second, I just want to zoom in a little because it looks like I'm too far away that you may not be able to see me. So give me 1 second.
All right,
Is that better?
Sebastian, can you put the Zoom up on the screen here in the chambers, please?
Can we get him on our screens?
There we go.
Go.
There we go. Now we can see Mr. Campanelli.
Oh, great. Thank you.
Okay, welcome.
Thank you for affording me an opportunity to speak tonight. And I want to start just by saying, for commending Brandon Swanson. I've dealt with local governments across the entire United States. I've been providing guidance to local governments for decades, and I will tell you that Brandon is an outstanding asset for the city. He's phenomenal. That's the best way I can describe him. So kudos to you, Brandon. And with that, I want to talk about your ordinance. Now, as you may or may not be aware, some of your constituents retained my services to draft a proposed ordinance for the city of Carmel. And as Branson mentioned, I'm not admitted to practice in the state of California. I am admitted to federal courts in California, the Ninth Circuit, the Supreme Court, that's fine. But I handled cell tower cases across the entire United States. I've been handling them since the Telecommunications Act was adopted back in 1996. I like to think I'm on the front line. I've handled many, many, many cases all over the country. And one of the things that I look at when I talk about a local ordinance or drafting an ordinance is essentially drafting an ordinance to accomplish two specific objectives. And they are, number one, to vest the local government with the maximum power preserved to them by Congress when it adopted the Telecommunications Act. The wireless industry never mentions this, but when Congress was thinking about adopting the Telecommunications Act, they thought about giving the power to control the placement of wireless facilities to the FCC. At the end of the day, they did pretty much the opposite. And basically what they did is they adopted a code provision, the first paragraph of which is subsection C7A, which is entitled General Authority, and within which Congress preserved to state and local governments the general authority to regulate the placement, siting, construction, maintenance of wireless facilities. That's never changed since 1996. Now, paragraph C7A is followed by paragraph C7B, which imposes what are largely procedural requirements on local governments when entertaining zoning applications. So with that power available to them, local governments adopt local zoning ordinances designed to achieve three objectives simultaneously. The first is to allow carriers to saturate towns, counties, and villages with coverage, while at the same time, number two, minimizing the number of facilities you need to provide that coverage, and number three, preventing to the greatest extent possible any unnecessary adverse impacts caused by the irresponsible placement of wireless facilities. When I draft ordinances, I take into account the law of your circuit. You're situated in the Ninth Circuit. I'm in the Second Circuit, but I've handled many cases in the Ninth Circuit. I do it all day long. So I drafted a proposed ordinance for the city. The city hired separate counsel to draft their own version. And I spent some time in a Zoom call with Gail and Brandon, and they've incorporated some of my suggestions. I think your ordinance, as so far as it goes right now, is pretty good. I think, quite candidly, mine would be better, but it is what it is. I do, however, feel, and this is in part due to something I didn't provide to Brandon, there is one fatal defect as the ordinance presently sits, and that is with respect to the evidentiary requirements, especially in the application process. Now, Brandon had asked me to provide him with suggestions for things which could be added to the application requirements. And I told him I would do that. I've not done that yet because I'm kind of on the forefront of the 5G rollout, and there's new case law coming down every day. There was a very important case of mine that came down in New York called Extenet versus the Village of Flower Hill, which made a very significant determination as to if and to what extent district courts are bound by interpretations of the FCC, and also what is necessary to establish an effective prohibition or a significant gap in service. And these are really critical to local governments when they entertain applications for wireless facilities. And so as I advise local governments, not just across the state of New York, but from Washington to Idaho to California, I impose upon them the importance, in fact, the critical importance, of usually incorporating into your code specific application requirements which are designed to ensure that at the time an applicant submits an application, they provide you with all of the evidence which your planning board will need to entertain the application and to make factual determinations. In lawsuits where municipalities get sued by an applicant whose application was denied, and they're claiming that you violated the Telecommunications Act, 95% of all these cases are based upon two theories, two claims. One, that the denial was not based upon substantial evidence, which addresses a specific requirement under the Telecommunications Act. It says all denials of wireless facilities must be based upon substantial evidence. And the other one is the effective prohibition. It says local governments cannot prohibit or effectively prohibit the provision of personal wireless services. Now, when any local government decides an application on a wireless facility, the grounds for denying an application comes from your local zoning code. It doesn't come from federal law. So you can deny an application for a cell tower wireless facility based upon things like adverse aesthetic impacts, reduction in property values, insufficient fall zone, all that stuff you build into your code. You treat it just like any other zoning application. However, once an application claims that a denial would be an effective prohibition, now your planning board has to make factual determinations which it otherwise wouldn't realize it has to make. Now, what does that mean? Well, until recently, the law was fairly clear. If an applicant wanted to claim that a denial of their application would effectively prohibit an identified wireless carrier from providing personal wireless services, they have to prove, number one, for a cell tower, that an identified carrier has a significant gap in personal wireless services, and number two, that the proposed installation is the least intrusive means of remedying the gap. In the Ninth Circuit, where you are, the ruling is that the applicant has to prove that denial would materially inhibit an identified carrier from providing personal wireless services. Well, how do you plan to enable your planning board to make a decision on those factual issues? They have to decide those issues. And so the answer is twofold. Number one, you have to provide them guidance as to what decisions they need to make. And number two, you must make sure that at the time of the filing of the application, the applicant is required to give them all the probative evidence they need to make that determination. So what type of probative evidence do you look for? So let me explain how it generally works. Let's say, for argument's sake, Verizon comes to the city and says, we have to put up a cell tower because we have a significant gap in personal wireless services. The legitimate way they approach the city is to say, based upon your terrain, the minimum signal strength we need to maintain reliable personal service is minus 98 dBm. That's the signal strength. And so what they'll say next is, so we did a drive test. We attached a recording device to a phone. We drove through the entire city of Carmel-by-the-Sea. We recorded the actual signal strengths throughout the entire city, and here's the data. This data, the actual probative hard data, will show you, number one, the existence or absence of any gaps in service, number two, the locations of the gaps, and number three, the geographic boundaries of the gaps. If and only if your planning board gets this data, does it place them in a position to determine, A, is there a gap in service? And B, if there is the proposed location sensible? Because if the proposed location doesn't remedy the gap, because there's other gaps open, they're going to be back 6 months from now for another wireless facility. So this is why, in general, local governments across the country ask for probative data in the form of actual drive test data. Now, very often they'll try to come in and say, no, we're not going to give you that. We're going to give you propagation maps. And they'll use software like an ATOL software, where they generate propagation maps sitting at their computer with no actual data. In 2020, the FCC's own staff told the FCC, you shouldn't accept computer-generated maps because they're completely unreliable. And for the same reason the FCC doesn't want to accept them, local governments across the country are wising up and they're not accepting them either. So for a situation where an applicant wants to claim, whether it's a site developer like a Crown Castle or an actual carrier like Verizon, that they need this application to be granted because there's a significant gap, at the outset, you should require them to produce probative data that there in fact exists a gap in service. And it should be produced at the outset, because if you wait till the public hearing, from the time between when they file the application, the public hearing, the shot clock is running against you. So you want to get it from the outset. Now, the other type of deficiency for which carriers would need a new facility would be a capacity deficiency. Now, this is a different type of need. This is a need where they have coverage, there's no geographic gaps, but the system is maxed out, which means at peak periods, maybe when it's rush hour and everybody's on the phone, the system can't handle the volume. Well, probative data for capacity deficiency is even easier. The FCC requires all carriers to maintain denial of service records. This is computed data stored on their computers, which records all failed calls. They can punch in a few keystrokes on their computer and give you an itemized list of all dropped calls for any geographic area for any chronological period in time. And so, again, I recommend to local governments, if they're claiming that they have a capacity deficiency, let them give you that data from the outset, because you're then arming your planning board with the actual probative data they need, which, number one, enables them to do their job, enables them to figure out if you need a cell tower, if it needs to go here, and if this is the proposed location makes sense. In addition, this is the type of substantial evidence which can be used to avoid, and if necessary, defend a claim that the denial was not based upon substantial evidence. You are asking them to produce at the outset the very evidence which would dissuade an applicant whose application is denied from ever suing the city in the first place. And even if they sue, they're not going to win. That's why you want that from the outset. In addition, again, of course, this serves not just for the purpose of proving that the decision is based upon substantial evidence, but it also goes to the issue of whether or not the denial constitutes an effective prohibition. Now, in the area of the effective prohibition, the case I mentioned earlier was a case called Extenet versus the Village of Flower Hill. And this raises a very interesting issue, which is being battled across the entire United States. And bear in mind, I'm fiercely loyal to my municipal clients. I don't want my municipal clients to ever get sued. And so far, none of them have. In the Extenet versus Flower Hill case, the applicant came in, a site developer, one of Crown Castle's biggest competitors, and alleged that Verizon had a gap in service because it had a gap in its 5G service. And so I represented homeowners who were opposed to the installation, and we created a record to establish that all they proved was a gap in one frequency within which Verizon provides its services. The problem, of course, is that Verizon provides its services on 7 frequencies. So when the application was denied, they filed a federal lawsuit. And in dismissing the federal lawsuit, the federal judge said, wait a minute. You understand that if somebody's on your system and using their phone to have a phone call on 5G, if the 5G signal strength drops too low, the phone will simply download to a 4G system or a 3G or a 1G. So the test for whether or not a significant gap exists is whether or not the carrier's customer can use their cell phone to connect to a landline. Now, when I spoke to Brandon and I was talking to him about the Extenet case, and he was suggesting to me that I give him proposals for what should be included into the applications, Extenet had appealed that decision to the Second Circuit Court of Appeals. But between now and then, they withdrew the appeal. So that decision is the final law. Now, granted, it's in the Second Circuit, but the law in the Ninth Circuit isn't too bad either. They have to prove, for an effective prohibition, that your denial would materially inhibit them from providing personal wireless services. And when I say they, I'm not talking about the applicant. I'm talking about the carrier. The question is, how are you going to arm your planning board to make those factual determinations? Planning boards ask me all the time, okay, they got to prove significant gap, least intrusive means, or material inhibition. Who gets to decide that? The answer is, if your code says your planning board gets to decide it, then your planning board gets to decide it. And I will tell you this. I've sat in chambers in federal courts across the entire United States. When a local zoning authority makes a factual determination based upon evidence in the record, they are loath to overturn them. Federal judges work very hard, but they don't want to be zoning boards of appeals. So I design these ordinances, and I suggest that you ask for this evidence and you give it to your planning board at the outset so they can make a decision and they can cite the evidence they have, which led them to draw the factual determination they made. The other issue I had was whether or not the code properly or sufficiently outlines the factual determinations they're required to make. I see that you made some changes, you've added some things. It could be better, it could be beefed up. And what do I mean by that? One of the most common ways local governments get sued in connection with this effective prohibition problem is when no one guides the board to make them understand what factual determinations they're required to make, most likely because they're not laid out in the Telecommunications Act itself. Classic example. Crown Castle comes along, they want to build a 100-foot cell tower 50 feet from Mary Smith's front door. And they file an application. Along with the application, they submit a propagation map, which was computer generated using ATOL software on the attorney's desk. No hard data. They also submit a letter from an RF engineer saying, we've analyzed potential alternative sites, and none of those sites will meet, and I love this part, will meet our coverage objectives, whatever that means. The planning board says, we looked at this and we don't understand. This is horrible. If you put this cell tower 50 feet from Mary Smith's front door, you're going to have a significant adverse aesthetic impact on her house, and it's going to reduce her property values, and based upon that, we're denying the application. What they failed to do is to make any factual determinations as to whether or not the applicant has proven significant gap or least intrusive means. You've just guaranteed you're going to get sued and that you lose because the planning board was not told what factual determinations it is required to make. The code, as they've now completed this first draft, is pretty good. But in my opinion, you should add what factual determinations you want the planning board to make. It's not critical, but it should be in there. And the application process or the application forms must, I'm not suggesting that they should, they must contain requirements for probative evidence to be submitted at the outset. If you don't have it, it's what I call a fatal defect. And to understand what a fatal defect is, this is what a fatal defect is in terms of wireless communications local ordinances. Think of it as the hull of a ship. If you build the hull of a brand new ship and 90% of that hull is made of the finest steel ever constructed, and 10% of it has a gap, there's a hole, that ship is going to sink and the hull is going to fail because there's an opening, okay? That's what a fatal defect is. If you don't require any applicant to produce the probative data to properly prepare your planning board and give them what they need to make a proper determination, then anything else in the code is useless. Because any sophisticated site developer will be able to walk in and put these things anywhere they want, and you'll be powerless to stop them. Now, that's not reflecting adversely on your existing counsel. I think she did a good job. I think Brandon has done an outstanding job, and he has asked me to give him suggestions as to what should go into the application forms, and I get it. And I told him I would do it, but I have not yet done it, only because these new decisions are coming down, and I wanted to make sure I could make it as complete as possible. So those are the main issues that I have with the current draft of the ordinance. Other than that, it's pretty good. I will tell you that of all the jurisdictions I've represented all across the country, Carmel-by-the-Sea is the most stunning location. You have the greatest natural aesthetic resource to protect, far greater than any other jurisdiction I've seen, even though I've never been there. Everybody sent me photos and videos, and it's stunning. And so I'd be perfectly happy going before a local judge and saying that, a federal judge, and saying they're trying to protect aesthetics, which is extremely valuable to the city and justifiably so. So with that, I don't want to bore you to death. If any board members have any questions, I've been doing this for 30 years all over the country. I've been in federal judges' chambers all over the country dealing with these issues. If you have any issues at all, please feel free to ask me. I'd love to answer them. Thank you.
Thank you, Mr. Campanelli. Are there any questions from the commissioners for Mr. Campanelli?
I have one.
Mr. Dells has a question for you.
So thanks for that. That was really good and very helpful. It's from my previous question, just a piece of it. In a situation where, for example, here we've approved a facility on the top of a theater. It's already approved, but it's not implemented or turned on. What are your thoughts on making the carrier turn that on before they provide the probative evidence?
The best way I can describe the answer is to talk about how federal judges talk about the Telecommunications Act. They hate it. They say it's not a medal of clarity. However, they say the whole intent of the Telecommunications Act is a balancing act. The intent was to balance the interests of local government in protecting their municipalities and enforcing the code against the interests of the wireless carrier building out wireless infrastructure. So I am of the opinion, and this is based upon if I had to sit in a judge's chambers and defend something a local government did. If you think about smart planning and somebody comes to you and says, we're Verizon, we need this tower, here's a gap in service and you have to let us put it here, I think it's perfectly legitimate, perfectly logical for an intelligent local zoning authority to say, wait a minute, before you tell us that you need this to provide services, there's no less intrusive means of remedying your gap. We want you to turn on the other facility. Because if you turn on the other facility, and then instead of needing a 100-foot tower or 30-foot tower, you could put a DOS node near here, that's a less intrusive means of remedying that gap. So by saying no, without you showing us that you can't cover this gap with that facility, you haven't met your burden of establishing that a denial is an effective prohibition. So I think the city is completely within its power to say, as long as it's the same carrier, okay? If the other facility is owned by AT&T and this application is from Verizon, it's a non-issue. You can't take into account. But if Verizon owns both, it is absolutely within your power to say, we need you to turn on all your facilities so we can get an accurate understanding of if in fact there's a gap and if this is necessary, and not only necessary, but necessary at the height you proposed. Perhaps you're applying for a 100-foot facility, but if you turn on that facility, you may only need an 80-foot tower here. So when you talk about least intrusive means of remedying a gap, the least intrusive means this site, this area, or this portion of this site, and building the facility at the specific height you want it. No shorter height can do. Well, how would you know that unless they turn on all of their existing facilities? I don't see any federal judge ever saying, oh, well, you wanted them to turn on all your facilities. That's unreasonable. I don't see it, and I've been doing this for 30 years, all over the country. No federal judge is going to say it was unreasonable for them to turn on their facilities so you can get an accurate understanding of the actual data. Oh, there's one other thing I forgot. In the visual impact analysis, there's language in your code that is troublesome because in the application, they ask for a visual impact analysis. And it says you want 3 sites from public roads. And that makes the hair stand up on the back of my neck because that's the precise language that the wireless carriers want to use. And I'll tell you what I'm talking about. Most local governments, when they're entertaining applications for wireless facilities, and especially cell towers, they would ask for visual impact analysis or visual simulations. The whole purpose of a visual simulation or a visual impact analysis is to give your planning board an accurate understanding of the actual adverse aesthetic impact that a proposed tower will inflict upon the community, and of greatest import, the homes that will be closest to the facility. One of the games that the wireless companies play is they will do a visual impact analysis, but they will deliberately omit from any such analysis any homes taken from the actual perspective of the homes that are going to suffer the worst impacts. They'll take photographs from a mile away when the tower is going to be built 50 feet from Mary Smith's front house, and they won't take any pictures from Mary Smith's house. This problem got so bad that in 2005, it reached its way up to the U.S. Court of Appeals for the Second Circuit. And in a case where they were building a cell tower on a golf course right adjacent to these people's houses, the federal court said the local government can ignore or regard the visual impact analysis as defective because it only included photographs taken from publicly accessible areas and publicly accessible roads. It did not include any photographs taken from the residents' backyards, much less their second-story windows. So if the visual impact analysis or photographs are going to serve the purpose for which they're intended, you should require applicants to provide photographs taken from the perspective of the closest homes that are going to suffer the worst impacts. That has to go into your code. So that one's a no-brainer. That should be in there.
Thank you.
Okay, are there any other questions for Mr. Campanelli? Once again, thank you very much, Mr. Campanelli. We appreciate your time tonight. It's been very helpful.
I thank you for the opportunity to speak. Thank you.
Okay, thank you. All right, at this time, I believe the Stop Cell Towers in Our Carmel Neighborhoods has a YouTube video that would like to be shown. Can we cue that up?
Yes, we can. Yes, we can.
And I appreciate the group doing this because I think it makes it very specific and makes it easier for us to gather information and focus on the things that need to be focused on tonight.
All right, can everybody see that also out in Zoom land?
Let's see.
Somebody wants to give me oh, Stephanie, you got you. Okay, good. I've got my insider here at the chambers. Okay, I'm gonna put it on full screen and we will, we'll go ahead and hit play on this and hope that the sound works. That's not it?
It's not it, no.
Oh.
I didn't think it was it.
That was weird, okay.
It's a nice piece of abstract art, but I don't think it was exactly.
Okay, stand by. Oh, I had it queued up for my, it's right here. Here we go. Okay, let's try this.
There we go.
All right.
That's it.
All right, Sebastian, can we get audio coming out of this? Oh, I probably have to, hold on a second. I think I have to share my audio. Hold on a second. There we go.
Wireless draft ordinance, making a best ordinance. In March 2022, local residents hired.
What's going on with the sound?
Yeah, we got a little bit of feedback going on here.
This resident-based wireless. Ordinance. In March 2022, local residents hired one of the top telecom and solutions to the city's wireless draft ordinance, making a best practice resident-based wireless ordinance. In March 2022, local residents hired one of the top telecom attorneys in the country, Andrew Campanelli, to write the strongest wireless ordinance to protect the residential neighborhoods of Carmel from cell tower proliferation. Mr. Campanelli's ordinance is not designed to stop all cell sites. It is designed to give the city the maximum ability to control where they go. Weakness. Rather than starting with the March 2023 City Wireless Ordinance draft and trying to strengthen it to the level of the Campanelli Ordinance. Solution. Start with the March 2022 Campanelli Ordinance for Carmel as the ordinance framework and make any additions to the Campanelli Ordinance to make it stronger. Weakness. The city draft does not articulate the role of the Planning Commission as the discretionary reviewing authority of evidentiary findings. Solution. In the city draft, the Planning Commission's role must be clearly articulated within the ordinance and the Wireless Ordinance Facility Application Checklist Types 1 through 4. Weakness. The city draft Wireless Ordinance Application Types 1 through 4 do not require applicants to provide all of the probative evidence necessary for the Planning Commission. Solution. the draft must require all of the probative evidence necessary for the Planning Commission to make factual determinations as to whether a denial of the application would materially inhibit an identified wireless carrier from providing personal wireless services. All the evidence necessary should also be articulated in the ordinance. Weakness. The city's draft has no deadline when applicants can submit special exception requests to the city. Solution. Require applicants making special exception requests to submit the request only at the time of application submission and no later in the process due to the shot clock deadline. Requests made later in the process will start over as a new application. Weakness. The city's application instructions state that applicants should include all the following information and/or materials and indicate whether tests were conducted. Solution. The city draft application instructions must require the necessary evidence from the applicant for the Planning Commission to be able to make factual determinations. Weakness. The city draft application instructions do not require an applicant to submit all the critical drive test data and map information. Solution. Require applicants to submit critical drive test data and map information necessary for the Planning Commission to be able to make factual determinations on significant gap claims. Weakness. The city draft application instructions do not require applicants to provide whether a mobile phone can connect to a landline. Solution. Require applicants to test whether a mobile phone can connect to a landline in the area to prove a significant gap claim. Weakness. The city draft application instructions do not require applicants to provide drop call records and/or denial of service records. Solution. Require applicants to provide drop call records and/or denial of service records in the area to prove capacity deficiency claims. Weakness. The evidentiary standards to be rendered by the Planning Commission are outside the ordinance and in the checklist. Solution. All the evidentiary standards to be rendered by the Planning Commission must be within the ordinance or in both the ordinance and the checklist. When neighbors work together with a passion for mutual values, including transparent government open to residents' voices, great things can happen. Thanks for listening.
Okay, once again, thank you for that presentation. It's very specific, and that's very helpful. All right, so the public comments are going to begin now. As Brandon said, we are trying to organize the comments under 5 topics. We have the application material requirements, location and design standards, application types and approving body, required conditions of approval, and then we have final any other comments. So I'm going to encourage you to try to focus on that, but if you have comments that you want to make, you can come up and make those. So at this time, I'm going to open it up to the public for their comments. So anybody would like to come forth and make their comments, please do.
So, Mr. Chair, while someone's coming up, we're starting with application material requirements. Is that?
You're right. But also any person can speak about anything.
Hi, Michael McWalter, Scenic 2 north of 11th. I'm just going to repeat what Mr. Campanelli said regarding the applications and what we want in the application. We want them to prove that they have a significant gap in service. And Mr. Campanelli's ordinance for stop-to-cell towers in Carmel neighborhoods had 4 hard data tests that are required of the wireless companies to prove they have a significant gap in service. So I just want to emphasize that that needs to be in the ordinance. Thank you.
Thank you.
Hello, my name is Susan Nine. I'm a retired California bar member and was selected by the City Council of Monterey to serve on its wireless ordinance subcommittee. As such, I have read countless wireless ordinances and most relevant state and federal case law. I agree with all the recommendations by Mr. Campanelli. We're so fortunate to have a community that was willing to put out the funds to have him draft this ordinance. I have not seen a stronger ordinance. This is by far the best structured and detailed, not only to help decision makers, but also the staff. It's very specific and detailed, and maybe most importantly, the public. When the public is faced with a permit application and they get those notices, the first place they're going to look is to the ordinance to try to understand this. The average person has no knowledge or understanding, even most lawyers, of telecom law. So it's very important. I'm going to focus on the application requirements because that's what you want to talk about. I agree with all of those things need to be provided to you, and they need to be provided to you before the application is deemed complete, because that's when the shot clock begins. The thing that I think is very important is that it also be incorporated into the body of the ordinance itself, which Mr. Campanelli did in his ordinance in great detail. The average person in the community will not know or even understand how to access the applications and the application requirements. They think everything is in the ordinance that's required, and they need to understand those things in detail in order to comment and become educated in them. All of those criteria that he alluded to as far as effective prohibition are contained in detail in over several pages in his ordinance, the reasoning behind them. It's just putting them in the application material is not adequate for the education of the public. Also, all pertinent definitions, such as the definition of a small cell, which is an FCC-defined term, all of those terms need to be defined in your definition section. Think of it as a layperson who knows nothing, and how this information, how important this is to the individuals involved in these comment periods. Thank you.
Thank you. Next comment.
Good evening, Chair LePage and Planning Commissioners. Christy Hollenbeck from Stop Cell Towers in Carmel neighborhoods. Thank you for giving Mr. Campanelli time to speak and answer questions. He has over 30 years experience, and he works tirelessly to protect people in local governments. He does not have a conflict of interest with telecom. I want to make it clear that we all want cell service. We are simply a group of residents who are trying to preserve the beauty, charm, and character of Carmel that drew us to live here. We do not want a weak ordinance that would give telecom companies and site developers a free pass to put as many wireless towers as they want, wherever they want. The Campanelli ordinance does not prevent cell towers from going in if carriers can prove that there is a gap in service. Mr. Campanelli's ordinance empowers you, the planning commissioners, to decide if a cell tower is truly needed, and if it is needed, where would be the least intrusive place to locate it. We don't understand why anyone would be opposed to that. It's a very reasonable request. Our village is only 1 mile square. We would like the city to map out exactly where all current cell sites are located and whether or not they are activated. We really should start there before we allow more towers in. More is not better. It's more visual clutter, it's more radiation, it's more fire risk. Some people might think, I don't really mind a topper on a telephone pole because I want better service. They don't realize that once you allow one carrier on a pole, other carriers can also co-locate on that pole if they choose. Noisy, bulky equipment can be added, and before you know it, you have a huge, ugly, noisy, bulky monstrosity in front of your beautiful, charming Carmel home. No one wants that. We can't allow carriers to come in and clutter up our village with the cheapest infrastructure. Carriers and site developers love locating in public rights of way in front of homes because it is the cheapest place for them to go. If they put a cell site on a building rooftop where it's hidden, they have to pay a monthly rent. Public rights of way are rent-free. They would like to put one every 150 feet. That would be lots of poles. We need to demand that carriers invest in quality infrastructure like fiber optics. Most Carmel residents would love to put unsightly utility poles underground. We don't want more visual blight in our beautiful town. The Campanelli ordinance is the strongest, most protective ordinance, and it was provided to the city for free. Let's start with that ordinance and strengthen it. Thank you to all the hundreds of supporters who have written letters, postcards, and donated money in support of our efforts. And thank you to the Planning Commission and to the city for working with our group and Mr. Campanelli. Thank you.
Thank you for your comments, Chrissy. Okay, our next speaker.
Hello, I'm full-time resident Tasha Witt. I'm part of the neighborhood group Stop Cell Towers in Carmel Neighborhoods. Our group supports cellular service in Carmel-by-the-Sea. Our group simply advocates for the city's maximum control over where cell towers go in our community to protect the city's character, especially the residential zones. The city draft has too many critical weaknesses that must be addressed. To save time, please review the 22 pages of detailed weaknesses and solution feedback sent to the commission and staff. Here are some of the most concerning ways the city draft wireless ordinance before you is weak. Number one, many of the findings are in the checklist but not in the ordinance. A judge will say that you can't make decisions on codes that are not within your ordinance. Number two, the city draft does not clearly articulate within the ordinance the planning commission's authority to make findings. Number three, the city draft does not clearly articulate the planning commission's authority to determine zoning laws and discretionary aesthetics, whose authority must be retained within the ordinance. Number four, the city draft does not require telecom applicants to submit all of the necessary data to prove a new cell tower is necessary. These findings must be listed within the ordinance for the planning commission to make factual determinations. Just so you know, for significant gap claims, drive test maps, we've given like Campanelli's specific way to test that, as well as whether a mobile phone can connect to a landline, and for capacity deficiencies, denial of service records or drop call records. We reaffirm that the Campanelli ordinance best supports the Planning Commission's authority by listing all of the necessary findings within the ordinance to make legal denials. To best support the Planning Commission, we strongly urge the Commission and the staff to refer to pages 30 to 36 of the Campanelli ordinance. The Campanelli ordinance is not designed to stop all wireless facilities, but gives the Planning Commission the maximum ability to decide where they go. The Planning Commission and staff have received over 400 letters and postcards from residents in support of the Campanelli ordinance. We fully support the Planning Commission's role in wireless facility permitting on a case-by-case basis to protect the city's character by preventing the proliferation of unnecessary cell towers and cell towers located in incompatible areas, by determining the least intrusive alternative locations and co-location opportunities to provide service to an area. Together, we can support cellular service and the least intrusive means to the community. Thank you.
Next speaker, please.
Mr. Chair, I do believe you have one on the Zoom whenever you're ready for that as well.
If I may make general comments, I think that this is probably one of the best things I've seen in 40 years in Carmel-by-the-Sea in terms of a meaty issue. You're working with meat and potatoes here. I know because I went through very much the same thing. You're in for a rocky ride ahead, and you're going to have all kinds of legalese thrown at you, threats, everything is going to be thrown at you. And I ask you to stay strong in making this the best darn ordinance in the United States, and I mean it, that you're going to have that. I went through that. It was a pleasure to be on a council that had very much the same issue. It was a national or state for sure issue. It was a short-term rental ordinance. Council went through very much the same thing you're going through now, the Planning Commission in particular. Tough act, tough nut to crack. The council and the Planning Commission stayed together on it. You got a very strong ordinance. Other communities have tried to do different ordinances, different wording, and haven't had much success. But stay strong, and I'm really impressed with the questions and the comments. And Mr. Campanelli just blew us out of the stadium. He's terrific. Now, Brandon apparently is going to look for a raise based on. But I want to thank Mike.
Please don't give away my secrets.
I want to thank Mike. You're in for a rocky ride. Buckle your seatbelts. Stay the course. and get us the best ordinance you can get it to council, and let's get it through. Thanks for all the hard work for you doing that.
Thank you, Ken. We have a couple of people online that have their hands up. I'm going to take Jean first. You want to unmute yourself, Jean, and speak to the chamber? Thank you.
Oh,
Thank you. I'm Jean.
oh, hi. Thank you. This is Jean McWalters.
Oh, sorry, Jean McWalters. We actually we didn't see your name on that. We're talking to Jean Rash, but we'll get you lined up here. Thanks.
I'm sorry. I'll mute myself again. Thank you.
Thank you. I'm
we
Jean
go.
Rash. I'm a resident of Monterey, and I'm president of the Monterey Vista Neighborhood Association, who with Susan Nine as our former president, we worked very diligently to get the best ordinance we could. The most important thing that has been said tonight is what Mr. Campanelli said, that Carmel-by-the-Sea is the most beautiful town he's ever worked in. I am so jealous that you have the opportunity to start to listen to his suggestions, that you have residents affluent enough to have hired him, that you're willing to listen to him. If I were you, I would start with his proposal and work from there. The video said it accurately. You need to start with his strongest proposal and go from there. You have the time, you have the funds, you have the motivation. You all want to preserve your town, and you can do it aesthetically. And you just really need to do it right. I'm so jealous. We in Monterey ended up with kind of a hodgepodge, and it's not the strongest, and we will be sorry, and you can do it right. I'm so proud of your city advocates and of what will come of this, because I have the feeling that you will do it right, and that you'll hire Campanelli and you'll start from the ground up and do it beautifully. Thank you.
Thank you for your comments. Okay, Carol Hall, why don't you go ahead?
Okay, thank you. I just want to reiterate and support what I've already heard. I think that Mr. Campanelli did indeed blow us out of the water. I hope that we start with his proposal and work from there. I think the residents of Carmel have done an awesome job in carrying forth with this proposal and hiring Mr. Campanelli. I just think we are fortunate to have residents who care so much about our community. So thank you to them. Thank you.
Thank you for your comments, Carol. I believe there was Adam Pinterest.
Thank you. My name is Adam Pinteritz. I'm the Government and Community Affairs Director for the Monterey County Association of Realtors. I want to first acknowledge staff and the commission members for having this very robust dialogue. And this is going to be general comment. You have some excellent experts here to help you out with the nuances and technicalities. I'll leave that to them. The realtors are concerned about and opposed to cell towers in residential zones. Obviously, the way that that preference is implemented in order to spare the city trouble, that I leave up to you all. But we are concerned, as Mr. Campanelli so accurately pointed out, about the values and the character of the city that people love so much. And you're blessed with citizens and residents who care very much about their neighborhoods. And I'm glad that you're listening to them. Thank you for your time.
Thank you for your comments. Cindy Lloyd, you want to speak to us next?
Yes, thanks very much, Mike, and members of the Planning Commission, city staff. This is Cindy Lloyd. Excuse me for a minute here. I can't be more proud of this group of citizens who have seen fit to hire Mr. Campanelli to protect Carmel from the cell towers as proposed. That's all I can say. Thanks.
Okay, I think Cindy's done. All right. I don't see any more hands online, so I'm going to go back to the chamber now. Is there anyone else here in the chamber?
Excuse me?
Oh, okay.
So I'm on a phone only?
All
Can I
right,
speak?
go ahead. Why don't you identify yourself and speak to the commission?
Yes. Yes, my name is Nancy Toomey, resident of Carmel, and I wanted to just, further support the comments that have been made here with a couple of reinforcements. I very much appreciate the work of the Citizen Committee and support the 13-point feedback that this team has prepared, and want to see as much of that as possible embraced in the next adaptation and rework of the ordinance in work in progress. The other 2 points that I want to call out is I would very much like, as I had requested some time back, to see pictures of examples of the different types of cellular facilities and any of their supplemental components, so that those of us who are not knee-deep in this technology, we get a visual example of what each one of these types might look like. I fully understand and recognize that technology changes. Things tend to get smaller over time, but not always. And again, I would like visual examples of each type of those facilities. The one other point is there was a comment made, a public comment made, talking to when the shot clock starts, but that was contrary to what I heard in the formal presentation up front. So I would like to have a double, triple confirmation of when the shot clock starts in each one of these instances, specifically what was said in the public comment, that the shot clock doesn't start until a complete submission is made. And I understand from the official comments that the shot clocks always start upon the initial submission, whether it's complete or not. So I would like to have that clarified inside this meeting, if at all possible. So thanks again to everyone who's been participating in making all of this possible, and all of the work of all of the teams involved. Thank you so much.
Thank you for your comments.
Mr. Chair, could I ask for clarification from Nancy, because we're information gathering. I want to make sure I heard what you said, Nancy. Thanks for the comments. They were specific, which is exactly what we're looking for. When you mentioned you'd like to see pictures of the various types of facilities, were you saying you would like that to be an application submission requirement, or you want to see those pictures in the ordinance?
No, neither, none of the above. It's more for the public education. Maybe it's in an information document that those of us who are not technically inclined on this information, that we understand what a type 1, a type 2, a type 3, a type 4 cellular facility might look like. So we're being critical appropriately if we need to provide feedback on a specific submission.
Okay, so we can bring that for the next presentation to the Planning Commission then.
Okay.
Yep.
All right. Thank you for your
Michael?
Thank you for your comments and questions.
Michael?
Yes.
This is Jean McWalters from San Francisco.
Okay, go ahead.
Oh, hi, thanks. I have a little speech. I'm also on Scenic Road 2 north of 11th. I would like to say that I do not want radiation in our neighborhood. Right now, our neighborhood does not have radiation, and I want to keep it that way. Your definition on page 5 in the draft ordinance, wireless ordinance, defines antenna as, quote unquote, an apparatus designed for the purpose of emitting radio frequency radiation to be operating from a fixed location for the provision of personal wireless service and any commingled information services. Do you know that people get sick living next to radiation emitting antennas? My question for the authors of this draft ordinance is, do you know that people who live next to radiation emitting antennas get sick? There was a major court case decided in August 2021 by the U.S. Court of Appeals against the FCC that said people are getting radiation sickness from these antennas next to their homes at levels less than the FCC guidelines for radiation safety. On looking at the plot maps of the Golden Rectangle, I calculated that each wireless company would install 13 5G antennas on each of the 8 streets in the Golden Rectangle.
According to the wireless companies, 5G antennas must be spaced 250 feet apart with clear line of sight to work properly. 13 5G antennas per wireless company times 8 streets in the golden rectangle equals 104 antennas, and that's just for one wireless company. There's at least 4 wireless companies. What you do for one wireless company, you must do for every wireless company. There's at least 4 of them: Verizon, Sprint, T-Mobile, and US Cellular. That equals 52 5G radiation emitting antennas on every street in the golden rectangle. That results in a total of 416 5G radiation emitting antennas next to 416 homes in the golden rectangle. Is there another way to provide the same services at 5G without emitting radiation? Yes, there is. It's fiber optics. Dale Byrne informed the community last year that Carmel is already laying down fiber optic on San Antonio, north of Ocean. Thank you. And I want to also say I fully support the Stop the Cell Towers and Neighborhoods work, and I just love Andrew Campanelli. I think he's awesome. Thank you.
Okay, thank you for your comments.
Thank you.
All right, yeah, come forward if you'd like to speak to the commission.
Greetings, my name is Sufyan. I'm just a fellow community member. Very interestingly, I was just reading that frame at the back of the board there. The city of Carmel-by-the-Sea is hereby determined to be primarily, essentially, and predominantly a residential city wherein business and commerce have in the past, are now, and are proposed to be in the future subordinated to its residential character. I think that's phenomenal. We want to make sure not to ever turn it into a circuit board. I'm a bit surprised that some of the suggestions and recommendations on the proposed ordinances by Mr. Campanelli were either overlooked or thrown out. I would highly urge that we all acknowledge that this cell tower game is actually a lot bigger than any of us small peninsula folk really understand. It's a lot more deep-rooted and complicated, and will have a lot of future consequences if we're not careful now. So I would highly urge that the commission or whoever's in charge, forgive the ignorance, but whoever's really behind the scenes, I would highly urge that you work very closely with him. The video was very eye-opening, and I think there's a lot that we could learn from with this gentleman who's so advanced and experienced. Thank you very much. And again, thank you to all the community for coming together, and you guys for putting on such a platform for everybody to be able to speak and come together like that. Thank you very much.
Thank you for your comments.
I thought we were going to follow the compartmental, but it doesn't look like it, so I'm just going to make my
Well,
remarks.
as I said in the beginning, everybody can make
Great.
whatever comments they want.
Thank you.
So, but if you want to make comments about the
I do,
agenda,
I'll
that's
I'll be
fine.
3 minutes. And thank you, Chair LePage. Thank you, commissioners. Thank
Mr.
you.
McWalters, I'm sorry, I'm going to interrupt you. I just need to announce that Commissioner Locke is going to leave us, so she's going to be leaving the workshop.
I'll submit.
Thank you. Thank
Okay.
you. Sorry, Mike.
That's fine. It's a working session.
That's right. Carry on, please.
Thank you. Unfortunately and disappointingly, if enacted, let me just start over again. Unfortunately and disappointingly, this draft wireless ordinance falls short on many fronts. And if it were enacted, it would also be in violation of our Carmel Municipal Code 170202, titled Purpose. The purpose of 170202 is to protect and promote the public health, safety, comfort, convenience, prosperity, and general welfare, unquote. This draft wireless ordinance does not do any of these, as you will see. Fortunately for us, we can rectify these shortcomings with the 1996 Telecom Act and with the Supreme Court of the United States and Ninth Circuit Court decisions. In 2017, then Governor Brown vetoed SB 649, which would have usurped our local authority and local control over the placement of antenna cell towers, and Governor Newsom vetoed a similar bill in 2021. Like SB 649, this draft wireless ordinance does the same thing. It takes away our local authority and our local control over the placement of antenna cell towers in our 1 square mile village, but we can fix it. Our local authority and our local control over wireless antenna placement is guaranteed in the 1996 Telecom Act, 47 U.S.C. 332, Section A, general authority, which states, quote, "Nothing in this act shall limit or affect the authority of a state or local government over decisions regarding placement, construction, or modification of personal wireless service facilities," unquote. This means that you, planning commissioners, decide to allow wireless antennas in our commercial district and prohibit wireless antennas in our residential neighborhoods. You can decide to do this, and it's not going to be decided by the FCC. You get to do that. By the way, we don't want any cell tower antennas in the R1 in the residential neighborhood. In 2005, in the Supreme Court of the United States in Rancho Palos Verdes versus Abrams, 544 U.S.C. 223, reaffirmed our authority and our control over wireless antenna placement. In 2005, the Ninth Circuit Court in San Francisco, Mobile PCS versus San Francisco, defined, quote, "significant gap in telecommunications coverage and the least intrusive means of filling that gap," unquote, which gives us the authority to require the wireless companies to provide us with hard evidence proving and providing that they have a significant gap in their service. And this requirement must be in our wireless telecom ordinance. This next one is very apropos. October 14th, 2009, Sprint PCS versus City of Palos Verdes. The Ninth Circuit Court said the City of Palos Verdes can deny access to rights of way on aesthetic grounds. How about that? That's pertinent. On August 13th, 2021, in an historic decision, the U.S. Court of Appeals for the District of Columbia judged in favor of environmental health groups and petitioners, finding the FCC violated the Administrative Procedure Act and failed to respond to record evidence that exposure to radio frequency radiation at levels below the FCC's current limits caused negative health effects unrelated to cancer, unquote. The adverse health effects from exposure to radio frequency microwave radiation include headaches, cognitive impairment, disorientation, sleep disruption, fatigue, tinnitus, vertigo, nausea, anxiety, and depression. The court found the FCC did not properly examine the evidence of long-term wireless exposure of RF radiation, radio frequency radiation, its impact on children, the people who were injured by it, its impact to the developing brain, the reproductive system, and to wildlife, and to the environment. For these reasons, we don't want radiation from wireless antennas in our Carmel-by-the-Sea residential neighborhoods. No wireless antennas in the R1, please. This is my last comment.
Okay, good.
Broadband wireless, also known as 5G, also called connecting to the internet, it's not part of the 96 Telecom Act. So there's no mandate on us to put it in. What we want is fiber optic. Fiber optic does not emit radiation. We're all about our health, besides enjoying this beautiful place. Thank you.
Thank you for your comment. Okay, our next speaker, please come forward.
Hello, I'm Bob Kavner, and I'm very proud, and in fact, I'm honored to be working with Christy and Tasha in the organization Stop Cell Towers in the Carmel neighborhoods. I feel we're on the same team. It's not like we're here in opposition. We're here to support you. We retained Andrew Campanelli because we wanted to find the finest logic, the finest experience in this very technical area. And my background is in this area. His knowledge is much, much deeper than the years I had at AT&T. I think he's done a very fine job. Brandon asked if they could talk with him, and we said, of course, if that would be helpful. And so that in our retainer, he has given advice, point of view to the city. I have a recommendation. We don't need to retain him. If you would like to retain him, we could stop our retainer. Take him on as you improve this document. I think he could be very valuable to you. If it's a budget issue, let us know. We'll go out and raise the money to support the extra attorney. But you should have the best on your team. We're on your team. Put him on your team as well. Thank you.
Okay, thank you for your comments. Okay, are there any other speakers? I see somebody coming up. They're coming up or leaving. They're leaving. Okay. Anybody else want to, in the public comments, want to speak at this time to the Planning Commission?
Well, I think, Mr. Chair, we might want to just offer that since we sort of deviated, we tried our best to make conversation buckets, but this is open now. If anybody thinks that they're not allowed to talk now because we're only on the application materials, I think it's fair to say that we'll take any comments at this point, right?
Yes, yeah. We have, I see a couple of hands up online. Tim Toomey, you want to speak? Unmute yourself. There you go.
Yeah, thanks. Sorry, I got cut off earlier. I was waiting to hit the right point on the topics of discussion that obviously we deviated from. But yeah, like others have been saying, I really compliment the Stop Cell Towers group, for all the hard work that they've been doing, and bringing Andrew Campanelli into the mix here. I mean, it's just really very informative and helping to get all of us, educated and up to speed on what we're up against. But I just have one specific example out of the draft ordinance that I'd like to run by you guys, and it has to do with the section 17.46.040, the general development standards, and item B, which ranks the locations and puts them into the three tiers that Brandon talked about earlier in his introduction. Tier 1 being less compatible, which is residential, R1, R4, senior citizen facilities. Tier 2, which is improved parklands, natural parklands and preserves, and theatrical. And Tier 3, the most compatible, which is central commercial, service commercial, community and cultural, residential, unlimited, and commercial. So assuming that this stays in the ordinance that we end up adopting, I have the following request for your consideration. To move the community and cultural, which is the A2, from Tier 3, where it's sitting in the most compatible, to Tier 2 for the following reasons. The Sunset Center is a cultural and performing arts center, which features concerts, comedy, theater, and dance, the same as theatrical, A1, which is listed in Tier 2. For example, the Golden Bough. Sunset Center is located primarily in a residential area with R1 zoning on 3 sides and RC zoning just on 1 side. Sunset Center also is a designated historical landmark listed on the National Register of Historic Places since 1998. So although there are existing wireless facilities on Sunset Center roof, and I don't know if this probably, probably doesn't eliminate the EFRs because there's already existing wireless facilities, but by going forward and moving out of Tier 3, which is the most compatible, I think we can ensure that it would be in a more appropriate and consistently ranked location. So I just throw that out for your consideration, and thank you very much.
Thank you for your comments. Mr. Myers, you want to go ahead? Unmute yourself.
Thank you. Good evening. My name is Ray Myers, and I live in Monterey. I'm the chairperson for Monterey Undergrounding. We're a citizens group that advocates for placing our utilities underground for safety, reliability, and to bring back natural beauty on the peninsula. Both Monterey and Carmel share many values and are currently both fighting to encourage our local governments to make a strong wireless ordinance to protect the quality of our lives. These ordinances should not restrict the wireless companies from placing ugly and out-of-character microwave broadcast antennas and radios next to our homes. I'd like to point out that many least intrusive alternative sites will still exist to satisfy personal communication service. because much is being made by the telecom industry about the merits of their new 5G generation of cellular standards. But the basic misconception is that this new technology will only work when cell towers are placed close to proximity to houses. It's factually untrue. T-Mobile, for example, offers 5G cellular services by way of a low and mid-band microwave frequency in macro cell facilities outside of residential zones. Densified antennas for 5G sites are really about selling us fixed wireless internet service to our homes and businesses. They're not about improving your cell phone service. Mobile wireless carriers have spent millions of dollars touting the benefits of 5G over the last few years, and their bragging makes it easy to forget the truth that most devices spend most of their significant time connected to your Wi-Fi. This is true of your smartphone as well, and of course it's absolutely true of your PC. It should also be known that there are alternatives to 5G cellular broadcast for internet. Fiber optic systems are becoming more available to homes and businesses. One brings fiber optic into their home and connects it to the modern style Wi-Fi 6 routers. It would be far superior to a 5G for security, speed, and reliability, and without sacrificing the aesthetics of our neighborhood. Wi-Fi 6 can produce speeds up to 10 times faster than 5G cellular and broadcast a very limited distance only within your property. So if your phones, cellular and landlines are linked to your Wi-Fi 6 or plugged directly into their Ethernet cable, then why do we need cellular for our internet and cell phones? You will still need cellular for mobility to be able to connect while you're in your vehicle or walking around the neighborhood. But do we really need cell towers every 250 feet on utility poles next to residents to achieve that mobility? Don't believe the red herring argument that we cannot stop progress or we must improve technology for our city, because everyone's in favor of improving technology. But we need to be able to say when that technology impinges on our city's character. And in some cases, it's just to improve this company's bottom line. Please make your wireless ordinance as strong as possible. Allow the city to control the placement of these cell towers before it's too late. We're flooded with ugly, unnecessary cell antennas next to our homes. Also, the telecom industry sells an inferior service that we do not want or need. Thank you.
Thank you for your comments. Okay, is anybody online here? Oh, Carol Hall, you got your hand up. Go ahead.
Yes. I forgot to mention last time a very specific question, which will make Brandon happy. Thank you, Mr. Myers. That was great information as well. One question I had was, if indeed someone wants to appeal a decision, a resident, for example, or a residential group, is there a fee for that? Is there a disincentive to be able to do that because it costs money? And if so, how much money does it cost for an appeal of that type?
Is that something you want to answer? Yeah, go ahead. Why don't you answer?
I don't, Gail can correct me if I'm wrong, I don't believe our ordinance contemplates appeal fees because our municipal code already does contemplate appeal fees. The way that it's contemplated is in the Coastal Commission's appeal jurisdiction zone, which is an overlay that sort of runs along the coast, and there's a section back by Mission Trails Nature Preserve. We do not charge an appeal fee. The reason for that is in the coastal zone, in the appeal jurisdiction of the Coastal Commission, if you charge an appeal fee, it just goes straight to the Coastal Commission. There's a proviso in the Coastal Act. In the rest of our city, there is a charge for appeals, and as it stands right now, that's the way it would apply to wireless. In every place I've ever worked, the reason for appeal fees, whatever the amount is, it means that you have to come with an actual reason. It's more about like when private development happens, so it prevents neighbors from appealing everything that happens when they don't get along. So we can look at, if the commission wants us to explore, creating a different set of appeal fees or how we treat that, we'll take that direction from the commission and explore that.
Okay. Thank you for that information, because that could make a big difference in what people are able to do financially.
All right. Thank you for your comment, Carol. Can we minimize that screen? Okay. All right. Anyone else here in the chambers that wanted to speak to the commission or provide some ideas. Christy, come forward.
Let's do one short one. Hi, this is Christy from Stop Cell Towers. Our ordinance so far is very solid. This is from, Mayor Dan Edwards from Dalton Gardens, Idaho, who had a Campanelli ordinance. Our ordinance so far is very solid. Mr. Campanelli knows what he's doing. No lawsuits, no application to date. Make sure you take his advice. Don't leave anything out. He has it in there for a reason. Sincerely, Mayor Dan Edwards, Dalton Gardens, Idaho. And Idaho is in the 9th Circuit District Court, just like we are. So thank you.
Thank you.
And also I wanted to say, I think it was mentioned, but the words matter. And when you say an applicant should provide probative evidence, you need to say that the applicant shall provide probative evidence instead of should. So, thank you.
Okay, thank you. Okay, is there anyone else that wants to provide some comment? Everybody had a chance to step up and have their thoughts communicated? Oh, Mr. McWalters, come forward again.
So at the last city council meeting, I described a request that I made to NOVA, Public Record Act request, for how much have we spent on this ordinance. Through July of last year, Carmel-by-the-Sea had spent over $114,000 on this ordinance between the two firms, Best and Krieger and the telecom law firm. And I asked, would you tell me, she used to send me the invoices from the firms, and it had ordinance or it had telecommunication service. That's how I know there was $114,000 that we've spent. So I asked for August of last year, August, September, October, November, December, January, February, March, 8 months. How much have we spent? And City Attorney Pierrick, there he is right there, he said, that's privileged. And I said, well, it's privileged this year and it wasn't privileged last year, so can you put that together for me so I get it? So what I'd like you guys to do, I'd like to ask you to do, tell us how much we've put out on this, because if it was 114 through July of last year, let's just pretend it's another 100, 150. We've put out $250,000 on this thing. And it's kind of a hard thing. I know I was a stockbroker for 33 years, and it's a hard thing to call a client and say, you know what, I made a mistake. We got to cut our losses. Let's sell this thing out. Let's go find some other better place for this money. So we're on the hook. We're on the hook. We've already spent it. And it might be a hard thing for the leaders of our city to say, you know what, we hired the wrong people. We should have hired Andrew Campanelli. In fact, last year, because Council Member Ferlito said, why don't we use other cities' ordinances to make ours and make it as restrictive as we can. So I formed the Golden Rectangle Citizens Committee, and I did just that. I used Calabasas ordinance, I used Petaluma's ordinance, put them together, sent it to you last year in April. And then Stop the Cell Tower in Carmel neighborhoods, put theirs together. You just put that together, guess what? How much does that cost Carmel-by-the-Sea? It's a goose egg, nada. Mine was free. His was $8,500 to the Stop the Cell group. We would have saved 250 grand. But it's a hard thing to admit you made a mistake. So let's just admit we made a mistake. We want the best for Carmel-by-the-Sea. We've got this awesome man named Andrew Campanelli. He's the best. He is the best. Let's use him. Let's use that ordinance. It's ready to go. There's some really good things in the Golden Rectangle Citizens Committee ordinance that I would like to put in there, namely 500-foot setbacks from any residence, an antenna setback of 500 feet from any building that has people in it, and 1,500 feet of spacing between antennas. Because let's face it, these things emit radiation. We don't want to get sick. Thank you.
Thank you for your comments. Okay, anyone else from the public? All right, I'm going to close the public comments, open it up, bring it back to the commission for their comments or direction. I just want to say, first of all, I really appreciate all the work that Mr. Campanelli did in his input. It was really valuable. But this really isn't him against the city. You know, it's not really that kind of a thing. We're trying to gather information here. And, you know, at the end of the day, we're gonna take a lot of Mr. Campanelli's input. I mean, he said himself, we have a good ordinance, a draft, but it's weak in certain areas, and he pointed those out and was very explicit about it and very convincing. And at the end of the day, we're gonna have an ordinance which we all want, which is to protect our citizens, to protect the character of our community in the strongest way we possibly can. That's the intent of this. And so we are going through a process, and I know sometimes the process seems slow in a democracy, but that's how we do it. And we also have to follow the laws too. So, so we need all your comments, and that's how we move this thing along, and that's what we're trying to do tonight. So, having said that, would you like to start? Commissioner Allen?
Yeah, I'll start. Let me decipher my notes here. So I especially want to thank all of the residents, because we do have some correspondence from residents who are concerned about cell service, and so I really appreciate everybody stepping up just so that this issue gets escalated to the point of where we are having these discussions, because I think they're super important. And I believe that we all have the same concerns. We all need good cell coverage. We all want to be safe. A lot of us depend on advanced communication technology to do our jobs. So we need to stay current and up to date with that technology. And finally, we all want Carmel to remain beautiful. So as a planning commissioner, it's important for me to ensure that we maintain this unique community within this extraordinary setting, preserving our forest character. Our design guidelines and our standards are regulatory tools to uphold the community's expectations, and these guidelines provide a basis for us to make good decisions. We have high requirements, and that same thoughtfulness should be applied here. Just like in our recent guidelines that we've spent 18 months on to look at, I want to use the strongest words so that there is no ambiguity, and I want the Planning Commission to have authority over these decisions. I want to ensure that we have the strongest ordinance that gives our community the most protection. I like how Campanelli's ordinance is easy to understand, and I believe that it has strong wording. To Christy's point, words do matter. So I want them to be extremely strong with no confusion. I'm assuming that the telecommunication companies have internal processes in place that need their cell tower placement to be a streamlined and cookie cutter type of process. But this isn't a cookie cutter situation or community. My guess is that any extraordinary process or one-off creative solution probably costs them a lot of money and time, and that causes them to, they would have to do things differently internally, and so they would have to put resources toward that project. But apparently this area must offer significant profitability. So I believe that it's reasonable to ask them to be more thoughtful in their approach. The sample pictures sent from their lawyers confirmed to me that they don't understand our guidelines nor our village in the forest. I'm a firm believer in data-driven decisions, so I want to require the drive test data and maps to be able to make the best choice. I want the wireless carriers to prove a significant gap in service and that the proposed site is the least intrusive means of addressing that gap. I also want to be extra diligent and leave out any confusion so that the ordinance and the checklist and the application contain the same information, even if it's redundant. If it's on the checklist, then it needs to be on the application and it needs to be on the ordinance. I would like photos for visual impact analysis, and I would like information to be able to make a decision on whether or not there's capacity deficiency. So I researched a lot of this, trying to get answers to my questions, and there was one specific McKinsey article about the advantages and disadvantages of 5G. And from what I can tell, it really doesn't have anything to do with cell coverage. It's about technologies such as AI or virtual reality. It's about streaming services, wireless broadband, gaming, and transition between cellular and Wi-Fi. And the article goes on to talk about how they can potentially utilize the 4G network, and they don't actually need to add or improve any of the equipment at this point. So I would like to propose that as we move forward, and especially if the Planning Commission is responsible for these types of decisions, that we align with a neutral subject matter such as academia or some sort of expert that we can identify as a neutral party to answer questions as we move forward and as the technology changes. So also the other recommendations that I would like to add is that I agree with Tim that I would like to move those locations to the appropriate tier, and then I also would like to recommend or align with the recommendation that we hire Mr. Campanelli for our team. And that's my comments.
Thank you, Commissioner Allen. Commissioner Delves, you're up next.
Yeah, thank you. Thanks, everybody. Yeah, great job. Best example of public process from the public side that I've ever seen, and I've been in public life for a long time. So really well done, and especially just so respectful of each other and of us, and I hope you'll feel the same thing back. I always feel the need to remind everybody that all 5 of us are homeowners and citizens of Carmel-by-the-Sea, right? So let me start. I'm going to get into the weeds a little bit because I think we need to go there, but let me start with a little history first and then some high-level stuff. Just going back to September of 2022, when we got the first version of the ordinance that was prepared in working with the Telecom Law Group. I was on record at that time that I thought that, and it was really 3 ordinances. For a lot of reasons, in my opinion, it was a non-starter. It was a mistake, in my opinion. And I'd love to get our money back. But we're not budgetary here. We are the Planning Commission. But at that time, I was pretty clear that I thought we just needed a new team. And I would have been delighted if we'd have gone with Campanelli. We went a different direction. Brandon and I talk a lot, and I just made the point that, okay, I'm skeptical of this, and I'm just going to pay very close attention to whatever comes forward, which I would do anyway, but that I had an extra dose of skepticism coming into this. I think this new draft is a massive, huge improvement over what we had before. It's not Andrew Campanelli's specific ordinance, but even at the time in September, I found some flaws. There were things in Campanelli's ordinance that I thought could be strengthened as well. I thought it's very good on some of the bigger picture items, like all this probative evidence stuff. I thought it was actually not as strong on some of the smaller minutia type things that we're going to get into here, because sometimes it's the minutia stuff that really gives us the ability to regulate more than the big picture, and we got to go both ways. So, Brandon, I think I applaud where we are, and I think what you've given us is absolutely directionally correct. And the idea of including Mr. Campanelli on our team, I was supportive of that in September. I'd be supportive of it now. I think he just demonstrated to us, and thank you for having him, giving him the time today, because it was really informative. It made me smarter. And I think it made all of us smarter. And to have that brain involved in our team, I think is a good thing. I don't think we need to have a do-over at this point. I think where we are is where we are, and it's okay. These others may have different opinion on that. But I think we can make the ordinance we have so far a lot stronger by including the most important things that Mr. Campanelli suggested. So let's go there. In my opinion, and I'm reading, actually, I already shared these notes with Brandon, and he and I spent a couple hours going through them, well, 2 weeks ago. I think the biggest thing that is missing is the same thing Mr. Campanelli said. I think it is the need to put the burden of proof on the telecom companies that they need a new tower. They need a new antenna. And the only way to do that is to prove that they have, and again, I think he's already provided, and his previous ordinance provides the language that you need, so I'm not going to try to repeat all those pieces here, but they have to demonstrate that they actually have a need. And whether that's drop calls or coverage, or it's the things that he has suggested. And I really believe quite strongly that we need those things in our ordinance. I also believe very strongly that we need, someone suggested to have a map. I think we do need to have an understanding, and that includes a map, of all the wireless facilities in our town. I mean, I would love to have a map of all of the utilities in our town, and know all the things. I think that cat's out of the bag, but at least with wireless facilities, I think there's a small enough number of them that it's reasonable for us to know where they are and if they are turned on or not. So that when someone comes in and says, we have a gap in coverage, you can say, did you turn that one on the Sunset Center on? And if not, you got to turn it on before we'll take your probative evidence. It's my opinion also that all of that needs to be upfront and part of the application. Another point that's been discussed is what needs to be in the actual ordinance versus checklists and other documents that aren't in the ordinance. And I understand that, especially because of the Coastal Commission, for us to change ordinances, having to get the Coastal Commission, that adds another layer of complexity that most municipalities don't they never approach. So I do think we need to be cautious. That said, and my concern of putting things only in the ordinance would be that there may be changes in the universe. Maybe someone will acknowledge that radio frequency at a certain level actually is something that we can protest to. I want to be able to move quickly and make sure we can add, or not just subtract, but add things as they come along, and that we don't have a year lag before we can add something beneficial to us. So Brandon, it's kind of just a drafting question, but I think if we put things in the ordinance and in the addendum type documents, that if we need to move quickly, we know we can change the addendum documents quickly. And is that enough?
Well, it's a good question. The answer would be, it depends, which is our favorite answer in the planning world. The reason it depends is because if the change you want to make to the application requirements, those sort of bolt-on documents, is in any way in conflict with the ordinance, then no. You won't be able to make those changes until such a time that you change the ordinance as well. If it's just adding something else to the bolt-on documents that somehow isn't precluded or is contradictory to what's in the ordinance, then you could do that. Then you have two different sets of requirements in your sort of regulatory schemata, which is not the best thing to do because you're going to confuse people. So that's the best answer I could give you.
Okay. I think we should err on putting as much in the ordinance as we can, and I think we can, with time, kind of maybe identify some things, okay, that maybe aren't as important to have in the ordinance and maybe are better, but I don't think it's an all or nothing. I think the most important stuff needs to be in the ordinance. Maybe, so now I'm going to get into the weeds a little bit. First off, just starting, and sorry I'm going to get page by page here, but I think it's what we're going to do. Perhaps in the whereas sections, there could be some acknowledgement of what I learned today from Mr. Campanelli and others in the audience, about the Telecom Act's, the intent of the Telecom Act was balance, And it really specifically reserved local control. I think we should say that in the whereas section. Let's celebrate the things that the telecom companies want us not to know, but that we know. So I think that, that, and perhaps even the fact that whereas the Telecom Act of 1996 applies to cellular service, it does not apply to a need for 5G or subsequent technologies. Then I'm going to go to, so the next thing I'll go to is one of the things I like very much about this ordinance, which was not in Mr. Campanelli's, is the five types of applications. That was one of the things from the previous ordinance that I did like, and I'm glad we still have it. And no, that wasn't the Campanelli.
Yeah, that was.
Sorry.
Yeah, we took that.
It was the other one. I think it's very strong. When I went through it, we have, and again, we've talked through this once, Brandon, but they're defined kind of in three different places. They're defined in the definitions on page 9, and then there's a lot more language that's added at page 19, and then even more language that's in the application checklist. The language is not the same, so I think any definition of a type 1, 2, 3, 4, or 5, anywhere in this document needs to be exactly the same. Because this is just a usability thing. It's somebody, one of the women that spoke earlier, the attorney from Monterey, that I kind of tried to go through this thing as if I had to use it, and how user-friendly is it? And that's one of the things I just kept stumbling on, was these definitions of types 1 through 5. And I also struggled, and actually you helped with one of your PowerPoints today, was the word existing structure. It's very confusing what an existing structure is. That and you and I had this conversation that, okay, is City Hall an existing structure? So if we're going to put a facility on City Hall, are we putting it on an existing structure?
Which one is not proposed right now? That is just an example.
Thank you. And the answer that I heard today is yes. If we wanted to put another one on the Sunset Center is an existing structure, as opposed to putting a new antenna somewhere that doesn't exist and it's not on a building, it's just a big antenna. That would be a new structure. I would encourage you to go back in all of your definitions and make sure it's really clear what you're getting at there. In some instances, you describe type 1 and type 2s as co-locations, but I'm not sure they are I'm not sure that's true. Because I think what you said is that type 1 could be a new facility on an existing structure. That's not a co-location because it's new. So I'll get out of the weeds on that one, but I just found it very confusing. On page 7, number 12, this is a definition of a non-pole concealment structure. It means a structure within the public right-of-way other than a pole that can be adopted to conceal antennas and or accessory equipment for wireless facilities. Examples may include, without limitation, monuments, kiosks, bus shelters, and other street furniture. Let's not put that out there as something that we want in there. So my concern is by keeping that in even in the definition, someone's going to come in with an application saying, I want to put one on the bus stop. And right here in your definition, you say that's kind of okay. Well, if we don't put it in the definition, then we're not inviting that. This one's hard, but page 7, number 16, you define public right-of-way. Land or an interest in the land which by deed, conveyance, et cetera, is reserved for or dedicated to or open to the use by the general public for road or highway purposes, and then the term does not include private or public utility easements. And the question I had to you was, does PG&E have utility easements across the right-of-way? Because if they do, that's where their utility poles are.
And they do not.
They do not. Then I think it's okay. Concern was if we exclude the easements, we might be excluding the poles and we wouldn't be able to regulate them. But if they don't have an easement, then we don't lose that ability. Page 12, B1. This chapter shall not be applicable to the following: wireless facilities operated by the city for public purposes. I think anything operated by the city for public purposes needs to go through the same doors as anybody else. And I don't know what others think of that, but concern would be some future city council really needs money and knows that they can sell the roof, and if it's excluded, not have to go through the public process. Let's not open that door. On page 13 on the tiers, I am perhaps not as supportive of moving the community and cultural from tier 3 to tier 2. Although I would go along with it, but my initial reaction was because the Sunset Center is already, already has 2 towers on it. I think Mr. Tomey acknowledged that already probably makes it going through the EFR process. So I'm not sure what the point is. I'm open-minded. Okay, page 15. These are important. We have a section here on additional public right-of-way location selection standards. One is directly in front, so it basically says no structure is technically feasible and available outside of these locations. So directly in front of the areas which are 5 feet in either direction from the center line of each entry doorway or window in the front facade of any occupied residential building. So that's basically saying if you've got my house, if I've got a window or a doorway and I go visually out that to the curb, you can't put a facility 5 feet in either direction. That's a lot. This is one of those small things that's a big thing. The previous version, actually the Telecom Law Group one, also had a similar thing that it could not be within 5 or 10 feet, I forget, it might have been 10, of a driveway or a walkway. I don't know if you would be amenable to adding that one in too. It's a bit of a belt and suspenders, but I think that really provides a lot of protection for the R1 district in addition to what we've already put out there. And then the other one is within a 250-foot radius of another wireless facility within the public right-of-way. Make that 500. I mean, we're drafting this ordinance now. That's a lot more. And it starts to get to some of the questions about that Mrs. McWalters, and her math of ending up with many, many, many towers. Well, 1,000 feet, and it's not just from one of yours. It's not from a Verizon to a Verizon. It's of anybody's. So I think that's a pretty significant challenge to overcome. And on page 27, the question is about fall zones, and the language for the fall zone was in one specific piece of the ordinance, and I think it needs to apply to all, that basically said if you take the height of the structure and add 10%, and it would then fall on to I don't think I said habitable, I think it said residential structure, then that's not allowed. I'd like that fall zone language to apply to any structure, and not just residential structures, but habitable structures. So I'm particularly thinking about hotels and motels, and because there's always people, any place that there's people inside of it. I think that fall zone protection just seems like a very specific example of public safety that makes sense in general. Last one. Again, one of the previous ordinances, I think it doesn't matter which one, had language for annual RF compliance reporting by these providers, and I don't see that in this ordinance. I liked that before because I don't think they care what frequencies they're kicking out, as long as, regardless of their motivations. I think we should know what levels of RF each of these facilities are putting out on an annual basis, and I know that adds burden to you and your team, but I think it's a big deal. That's my journey through the weeds, so thank you.
That was great. Thank you. I really appreciate that.
You did your homework.
Yeah, no, I mean,
we're going to give you an A+ on the homework assignment.
The devil is in the details, so thank you very much.
Well, we had a lot of detail here tonight, and we all appreciate it. This has really been a great workshop. I'm not going to go over a lot of the stuff that has already been said, but I am going to say that obviously Mr. Campanelli made a few really strong points, and one of them is that we have require that the Planning Commission or the application have the probative data ahead of time, and he specifies that out in his ordinance. I think that's a key point. We need to have that. That's very important. Otherwise, we're just getting into subjective things. And what's imperative upon the cell providers is that they have to provide data that they have a need, and that's I think Mr. Campanelli has addressed that in his wording. So I would recommend to staff that they go over that wording, incorporate that into our ordinance. The other point that he made was that information that's in the application should also be incorporated in the ordinance, and I think that's true and very important. So he's got that laid out there, so there's already a model that you can use to do that. The big takeaway I had from Mr. Campanelli is that you need to get this specific information in there so that at the time that the application is filed, the information is there, because the shot clock starts running, and then you don't have the time to do it. So there are some ways that some conditions where the shot clock can be stopped, but they're pretty limited. So we need to make sure that we have the information, all the data available at the time, so that we know we can prove that the need is there, and that the burden of proof is on the applicant. But other than that, I thought I think your staff has got all the input here, so I don't really have a whole lot to add, and I don't want to take up any more time here. I think everybody else has done an excellent job, and we really appreciate it. So, is staff good with your clear on?
I think so. I have a couple, if it's all right with the commission, I have a couple of just clarifying points. I think I heard some of the big ones. I just want to make sure. So, one of the points we put up in our presentation talked about where things live. Things living as I've been calling them bolt-on documents and in the ordinance. So. Obviously, we're missing 2 planning commissioners, so I'm dealing with those. And we're going to get comments from Commissioner Locke in writing, as well as Commissioner Bolton, who wasn't able to join us. He had a family emergency. He did text me, but he will provide comments. But from what I'm gathering from the 3 here, is not necessarily, because remember, like the application material and the application and the design guidelines and the conditions of approval, those are pretty lengthy documents. So it's not necessarily to take all of those as like physical pieces and shove them into the ordinance. More about finding what are the important things, continuing to work with Mr. Campanelli, what are the important things in the application requirements and the checklist that should also be codified in the zoning ordinance. Is that, I'm seeing 2 heads go up and down.
As an example, I think this probative evidence stuff belongs in the ordinance, but design guidelines don't.
Okay.
I think they can.
Because there's already a host of design guidelines in the ordinance, and then there's additional ones that live outside, so that the ordinance isn't so burdened by, doesn't become a 100-page ordinance, basically. Okay, so thank you for that, and I'll double check with the other commissioners too and make sure that's how they felt. I do want to make one comment, and it probably isn't going to be the most popular comment in the world based on what I heard tonight, but you will recall that when we were earlier in the process, we did actually ask the city council if they wanted to explore retaining Mr. Campanelli, and they did say no on that for a host of reasons, one of which is the fact that he's not admitted to practice law in the state. But having said that, they did give me the authority to work with Mr. Campanelli as an outside sort of consulting with our city attorney that we have hired and that we have chosen to work with, the city council has chosen to work with. So I'm totally comfortable continuing to work with Mr. Campanelli. He was very, very kind and gracious to mention that he wasn't able to get to something. I wasn't going to bring that up. That was very kind of him and very big of him. So I've very much enjoyed working with Mr. Campanelli. I'm going to continue assuming that the group that's funding him is okay continuing for me to work with him. So we'll continue to work with that. I'll get that very specific information that we were hoping to get about what materials need to be in the application requirements. So I just wanted to put that out there. I know the Planning Commission, some of you said you would like us to retain Campanelli, but it's a city council decision. It's not something, as someone put so wisely, the Planning Commission is not a budgetary body. We did ask that question early in the onset. So unless we get other direction from the city council, we're going to continue with our city attorney, who we do think is doing a good job, in collaboration with Mr. Campanelli, who's been very generous with his time and has been a good collaborative partner in this. I don't see that changing, so we'll continue to work with him. That's all I have.
Okay. I want to thank everybody again. I think it's been a really good workshop, and I am sure that we will be able to draft the strongest ordinance possible with all your help. Thanks so much. We are adjourned.
Thank you, everybody, for coming.
Thank you, Brandon.
Oh, yeah.
Your public was well organized.
Oh, thank you. Oh.